think November month government taken 2 weeks time, but not off list stage maybe. Next week.
Okay. 16 February.
One matter they filed yesterday, madam. Can it be come for motion tomorrow or Monday? Madam?
Tomorrow not possible, taking into account that your bar president said that there should not be motion on Saturday.
Monday, madam, Monday.
Lordship, I am appearing on behalf of Mr. D. Upamanyu, Lordship, seeking an adjournment in item number 16, Lordship. His father is not well, Lordship.
Item number?
Item number 16, Lordship. We have taken consent from the other side, Lordship also. They have consented to.
Affidavit filed?
Affidavit filed, Lordship.
Is there any interim order?
No.
Who is
No.
appearing for the other side?
I am again. Yesterday night, he rang me up, my lord, his father
His
is,
father is not well, Lordship.
although there is an urgency, my lord, since his father is in my lord, I agreed.
Father is not well.
Not well, Lordship.
So, my lord,
At
take
the
3 weeks, my
request
lord.
of the
Non-payment of pension, my lord.
Standing Council of the Health
Of
Department,
11th, Lordship.
let the matter be listed again on 11th of February 2000.
Obliged.
Obliged.
They pay for a mention of a petition in the admission column, madam. Family pension relating matter. Actually, notice is already served. 11th or 12th, madam.
18th.
May I please, Your Lordship? Lordship, a motion matter for Monday, my lord.
What?
May I mention a motion matter for Monday? This is in respect of the appointment of the PP. DPO.
Wait, Mr. Lord. Sir, I beg to mention item number 30, Lord. Here the petitioners have received their entertainment.
30.
30, Lord. Matter pertains to non-payment of areas salary and fees released, Lord.
Mr. H. Talukdar, appearing on behalf of the petitioner, submits that the petitioner have already received the dues, and as such, nothing further remains in the writ petition. Accordingly, the writ petition stands closed as it has become infructuous. Interim orders, if any, stands vacated.
Contempt case in order of contempt case.
When? Hey, next week or did you?
May I please? Yes, I'm praying for listing on contempt matter. It will come upon next week, Lord.
Next week.
Then motion matter, my lord, Monday, my lord. Obliged.
Yes, with the lordship. In respect of item number 41, lordship, the lordship is fixed for further consideration. I filed an additional affidavit to bring on record certain notifications of the central government, whereby certain, which we can allow to call.
May it please your lordship. Lordship, may I make a prayer for the listing of a matter in the admission column? It was last listed in the month of November, your lordship.
Okay. 20.
Deeply obliged, lordship.
Lordship, we are paying for listing the listing matter for admission column on 12th February.
Matter pertains to?
No payment of pension.
Okay, 20.
Wait, please, Your Lordship. Lordship, I look to pray for a listing of a motion matter for Monday, Lordship. Much better.
Promotion item हुआ
The next plan was to gather the instruction. And notice was not issued on the very first day, although an interim direction was granted. Notice was not issued on the very first day of it. So if the instructions are still awaited, I pray that notice may be
Yes,
issued.
Lordship. Notice may be issued and in the meantime, we will file our reply, Lordship.
Matter has been going on for such a long time. You have sought for instructions many times.
Lordship, some instructions.
And Mr. Bhardas, there's no interim extended on the last occasion.
I have neither mentioned it, but not extended method.
Then- Then you have to satisfy me about the case again.
It is
You want this court to extend the interim order.
still holding the charge of chairman. He's still this.
No, now tell me, by way of an interim order, if it is given, what will happen tomorrow? If your writ petition fails? Give me a good idea on this. How do you take care of that situation?
The term is of 5 years.
Understood. But as of now, what has happened that this particular urban local body have been dissolved. It has been dissolved. So if it is dissolved today, it has already been dissolved by operation of a particular law. We have challenged the law. The law has not yet been set aside. So under such circumstances, if in the circumstance that you are being thrown out or your writ petition is dismissed at a later stage, how do you take care of the amount which you have received as salary or remuneration? Give me a good idea on that. And why you are not coming up with these things?
Lordship,
It is very unfortunate on the part of the BTC. You don't know anything about this case.
Lordship, these persons were removed from their.
Understood,
Yes,
but there
Lordship.
was an interim order passed.
Status quo order was given on the. last of
Understood.
it, Lordship.
Status quo means what? He is no longer in service.
Yes,
This is what has been mentioned. So therefore, if it has been dissolved, how can he get an interim direction? It is like a person being terminated and this court passing an order that continue him.
but Lordship, he approached before this court and he is claiming that he is getting the salary. Now, where is the documents or any proof that he is still now serving and getting salary?
There is a statement in my repetition based on which this court was satisfied and the interim direction was granted of status quo. What has happened is on date when the first order was returned was passed. And that day my charge was never taken away. I was serving and I made a statement, particular statement. And based on those.
Understood. But the fact that it doesn't happen, the body is not there. What are you working on?
I don't.
My question is where you should have something. When the body is no longer there, how can you be some chairman of that body?
So the development authority is there, my lord, and my post was a statutory post.
Understood, everything is
And
understood,
the
but
scope of it-
but tell me, you see, in the interest of public service, so and so, where is that document?
Page 50.
All as desired by the Honorable Chief BTC, all non-statutory, non-elected ad hoc organizations, boards, committees are hereby ceased from immediate effect. The Secretary of the Department shall issue notification with respect to the bodies. In pursuance to this, and as desired by the so and so, the Boroland is hereby, Territorial Council is pleased to dissolve all municipal board and urban level under the BTC with immediate effect. This happened on 10th. So if there is a stay to this, it's a different aspect. You may continue. But how do you continue otherwise? This has already come into effect.
What has fallen from your lordship, I believe that the instructions will be required.
Understood. So have you asked for stay of that document? So if you have not asked for stay of that document, then how do you remain? How can you function?
Prayer was there, but the court granted status.
Prayer was there. Fellow, they have not provided instruction which stay that document.
At page 10.
We stayed this document.
Lordship, Lordship,
We
as
stayed.
there is
No, madam.
submission.
The moment we stay this, you know the effect, what will happen.
No, Lordship, Lordship. Notice has
Because
not been
you-
issued, Lordship.
Notice on interim prayer was issued on 27/10/2025. And till date, you have not obtained the instructions.
Lordship, that is only status quo order was obtained. And there is no documents that they were in service, Lordship. So
Madam,
on that,
kindly see the order of 27/10/2025. Do you have a copy of it? What is the line prior to directing the parties to maintain status quo? let notice be issued on the interim prayer returnable on so and so. Meaning thereby, notice was issued on this aspect. Then you have no instructions. So we stay this. We stay it.
No, Lordship,
2 o'clock. Ask your senior, whoever it is, to come.
then.
2 o'clock. Otherwise, we are going to stay it or you get your instructions. This can't happen like this. And what type of order you have got? Status quo.
My husband was died in the year 1998, and he received only leave encashment matter, but in the year 2019, my lord, he was died, my lord, without any pension, my lord.
Yes.
If my-
Commissioner and Secretary PNRD.
My lord,
Why you have not complied with this direction? Have you complied of this 5/12/2016?
my lord, I have to take
A
instruction. of that.
person died to be yet to get. Also get the names of the officers who are responsible.
My lord.
Because this can't happen like this.
Yes, my lord. I'll take the instruction, the reason why he's not paid.
This is a very serious thing. A person retired. What do you wanted? Have you taken up these steps? And it has happened in 2000. The
Well-
person retired in 2013? 1998? No, 2013. No.
Retired 1998, my lord.
Then
2015, my lord, he what?
Leave
leave
encashment.
my lord. Page 15, my lord.
have you got the interest along with the leave encashment? Lahu, issue notice making it returnable on 27th of February 2026. Pusto. Mr. S. Doctor accepts notice on behalf of the respondent number 1, 3, 4.
Yes.
Mr. A. Chakraborty accepts notice on behalf of the respondent number 2, Accountant General.
Execute.
Have you seen any of these Accountant General councils? Mr. B. Chakraborty, R.K. Talukdar, anybody of them?
নাম লেখাইছেন নাকি? নাম লেখাইছেন নাকি? লেখাইছেন।
Name has been shown, lordship.
Whose name?
As
None has appeared on behalf of the accountant, office of the accountant general, that is the respondent number 5, though their names have been shown and copies have been served. Pusto. Taking into account that the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition will be served upon the councils during the course of the day. As regards the respondent number 5, a copy be served upon Mr. R.K. Talukdar, the Standing Counsel of the Office of the Accountant General, AE, Assam. The petitioner, at the outset, it is very pertinent to take note of that the petitioner is 84 years old. Her husband, who was rendering service as a tax collector under Solsarpa Anchalik Panchayat, Kachar, Jila Parishad, retired on 28/2/1998. Full stop. Unfortunately, it was only in the year 2013 the pension proposal was forwarded by the Office of the Chief Executive Officer, Kachar Jila Parishad. . Full stop. In the year 2015, the husband of the petitioner received leave encashment to the tune of rupees 48,256. On 5/12/2016, which is almost a decade ago, the Director of Pension returned a proposal citing certain procedural deficiencies and directed resubmission after removal thereof. The husband of the petitioner, expecting that he would one day receive the pension, expired without the finalization of his pension. First, the petitioner had also submitted a representation before the concerned respondent authorities, but the petitioner is yet to know its outcome. Considering the above, therefore, the petitioner, at the age of 84, is compelled to approach this court, knock the doors of this court, seeking redressal of her grievance. The materials on record shows a very dismal state of affairs. Considering the above, this court therefore directs the respondents herein to bring on record their stand as to why the petitioner have not received, why the petitioner's husband as well as the petitioner during his lifetime, as well as the petitioner, have not been provided the pensionary benefits. The said affidavit be filed on 25th of February 2026. This court further directs in the interim that in the meantime, pendency of the instant, this court further observes that that till the next date, it shall not be a bar on the part of the respondent authorities to process the pensionary entitlement of the petitioner, and thereupon submit an update on the next date.
Lordship, my voice is there, and I'm being low because I have a bad cough. I apologize for that. Lordship, I am a constable GD of the CISF, and I've rendered 17 years of service, sincere and dedicated service.
Mr. Chaudhary, you are appearing for
Yes.
CSF.
Yes.
Why are you not disposing of the appeal? There's an
Take-
appeal filed.
Yes,
Yes,
yes.
there is a delay of 28 days
Yes,
in
I see
filing.
it, yes.
Consider it. We dispose it of.
Can I get the instruction, Lordship? Or?
Consider it. If you have dispose of,
Yes,
and inform him about the disposal.
disposal.
If you have not disposed of, dispose of within
Exactly.
30 days. Makes no sense in keeping the matter pending. Heard Ms. P. Bulwer, the learned counsel appearing on behalf of the petitioner. Mr. S.P. Chaudhary appears on behalf of the
CISF, Lordship.
on behalf of the respondent numbers 2 to 7.
7. One is also
Union
there.
council, no union council.
One is also there, Lordship. I'm appearing for one also.
Home? You are also home?
Yes,
Mr. S.P. Chaudhary appears on behalf of the respondent numbers 1 to 7.
7.
The petitioner herein has approached this court, taking into account the matter in the entirety. This court takes up the instant proceedings for disposal at the motion stage. The petitioner herein have assailed the order of removal dated 7/8/2025. and further seeking an independent and impartial inquiry into the irregularities and the security lapses, and further seeking certain consequential directions. Be that as it may, it is very pertinent to take note of that in pursuance to the order of removal dated 7/8/2025, the petitioner had filed an appeal
Five, 10, 20, 25.
on
5, 10, 20, 25.
5/10/2025. Pustak. It is also stated in the memo of appeal so filed before whom? Where's the appeal?
That's one number 4.
Before the appellate authority. That is the Deputy Inspector General CISF.
5.
That there is a delay of 28 days in preparing the said appeal. It is the further contention of the petitioner herein that the said appeal, which so filed on 9/10/2000, on 5/10/2025, have not yet been disposed of or considered. Taking into account that there is an appellate remedy available in terms of Rules 46 of the CISF Rules 2001, and the petitioner have already filed the said appeal, it is the opinion of this court that the appellate authority should be directed to consider the said appeal on merits and dispose of the same, if not already disposed of. Accordingly, this court therefore disposes of the instant writ petition with a direction upon the Deputy Inspector General CSF, who is the appellate authority, to dispose of the appeal filed by the petitioner dated 5/10/2025 on merits without insisting on the question of limitation within a period of 60 days from the date as within a period of 60 days from today. Full stop. It is further observed and directed that in the circumstance the appeal had already been disposed of, the appellate order be furnished to the petitioner within a period of 30 days from today. Full stop. A copy of Mr. S.P. Chaudhary, who appears on behalf of the respondent numbers 1 to 7, shall duly intimate the appellate authority about the order so passed, about the order as well as the directions, about the present order as well as the directions so issued herein. Next. This court further observes that if the appellate order so passed against the petitioner is not favorable to the petitioner, it shall not bar the petitioner to approach this court provided there is no other alternative and efficacious remedy.
Apologies.
Much obliged. Your Lordship, matter relates to.
Madam, first of all, where is the policy? Where is the compassionate appointment policy? I also understand.
The grounds of rejection of my application was not delay, Lordship. The grounds of rejection of my
application for compensatory appointment is not delayed.
Is not
Delayed.
delay. I'm not on delay. Your father expired in the year 2021. It's not a question of delay. The reason why it has been they have rejected is that taking into account that you have a corpus of around 40 lakhs which you are going to get, plus there is a family income of around 26,000 and other benefits, your income would be around 71,000 compared to what, and they have a policy that if it is more than 60%, then you are not entitled to. So therefore, where is the policy? Without that policy, how do you have a case? Because compassionate appointment is a right, is not a right. It is based upon a policy. If we don't have the policy with us, how do we issue notice?
Monday also.
Next week you'll get a good judge. Place the matter next week. For motion. And date is a deliver Friday.
If a politician in year 1993, and he was retired from service in the year 2000. He rendered service more than 30 years. Lordship,
You're retired? You have got your last.
Lordship, now I am only paying for pension. Lordship, I have.
How can you be granted pension?
I am relying a judgment to pay export, export judgment, Lordship. Lordship, kindly come to page. Lordship, 31.
What does it say?
Lordship, in this judgment, Lordship, apex court consider the perennial need of the service as well as length and the long service.
So why after retirement now you want the regularization to be given on effect from somebody? You were appointed when?
Lordship, that is Lordship. Direction is there, page 36. Lordship.
Why on 7th of October 2005, when your fellow people have already been regularized, why didn't you approach this court? Thereupon, when they again took another attempt on the basis of the judgment in Uma Devi in 2006, you were not regularized, whereby they had a policy in the year 2007 or 8 that those people who are working 10 years prior to this could be regularized. Why didn't you approach then? Why after retirement? Because the Supreme Court has passed a judgment. Now let's see the facts in Dharam Singh. You can pick up one paragraph here and there. Let's see what is Dharam Singh. Let's see the facts. Kindly see page 18. The appellants were engaged by the commission between so-and-so and so-and-so. Appellant number 1 served as class 4 employees. Served area, they were paid wages and with effect from so-and-so received consolidated so-and-so. The commission established under UPN so-and-so processed large so-and-so. Commission resolved to create 14 posts of so-and-so and sought sanction from the state government. On so-and-so, the state sought particulars of the daily wage hands and their service details. On here, commission furnished a further list of 14 daily wages. In so-and-so, the commission reiterated its request seeking sanction of 2 posts of drivers. Agreed the appellants instituted repetition in the year 2002, 2025 years ago. 26. Why should we, in your case, issue notice? We have got their minimum scale of pay. Should we be happy with it?
But after retirement, nothing.
So what? There are many people who doesn't get. Would a person get it if he's in private service? You want this court to reconsider Upenda's judgment. Upenda's judgment is because your case comes within those people. They came up before this court saying that kindly give me us regularization. The court rejected it, the division bench rejected it. But however, taking into account Jagjit Singh, as well as what the government expressed that they are okay, we are going to give them and shall not remove them, dispose of the petition, thereby giving that those persons who are working prior to 1/8/2017 for the 10 years, they shall be given the minimum scale of pay. You got it. You had it. And thereupon, after another 10 years, after retirement, you come before this court. You don't leave it to me. I reject it. You do one thing. Let me reject it here itself. And thereupon you go to the division bench. On this aspect, the division bench is very considerate. What do you say, Mr. Gogoi?
Not same.
No. What do you say? Wouldn't the division bench be more considerate on grade 4 employees?
Yes, Lordship.
I'm doing you a favor by dismissing it right now. On the submission of Mr. P. Nayak, that these facts cannot be applied. Isn't it?
Yes, Lordship.
Because issuing our notice of this in the matters of this kind would open another Pandora's box.
Lordship.
Isn't it?
Yes, Lordship.
So let the division bench look into it. Because your main hurdle is Upendas. Now, if in one case of this kind is allowed, all those people who had filed the writ petition in Upendas and did not get regularization, they would be also those similarly situated. There would be a violation of Article 14. Don't you think so? So in division bench, they can look over Upendas and refer it to 3 judges. And then we can look at it.
That is one. And secondly, Lordship, in Upenda's Lordship, all the petitioners were appointed prior to 31/3/1993. Here his appointment is subsequent. That is at a
His
third.
appointment is subsequent. That is why he didn't get in 2005.
Yes.
In 2005, all his other fellow persons have been regularized. Therefore, I asked him why in 2005 he didn't approach the court. The second comes at the time when Upenda's case comes. At that point of time, also, now then comes Uma Devi's case. Uma Devi says those people who are working for 10 years, okay, let them be given. Then also he doesn't come. Because he could have come in. Then also, you didn't come. All this while you wait and come at the age after everything. Because there is a specific law, the Supreme Court judgment, that one cannot give pension, divorce the pension rules.
Yes.
Although there is one judgment in your favor, but it's a one paragraph judgment of Justice M.R. Shah and Justice B. Nagaratna. One paragraph judgment. If a person has been rendering for 30 years, later on you cannot say that you are not going to grant them pension. This is the judgment, isn't it? One paragraph. Take help of that before the division bench. Heard Mr. Ella Mujumdar, the learned counsel appearing on behalf of the petitioner. Miss MD Bora, you are appearing for the finance, no? Mr. Pina, the learned additional advocate general, as well as the standing counsel of the finance department, appears on behalf of the respondent number 5. So and so, Ms. MD Bora appears on behalf of the respondent numbers 1, 2, and 3. Where were you? I put your name in another case. So should I put it that it is your name you appeared? So and so appears for respondent number 4. Hey, আগৰটোত সেয়া কৰি দিব. The petitioner herein, who had retired on, who had superannuated on 31/12/2024, have approached this court by filing the present writ petition on 19/1/2026 for a direction that the petitioner should be regularized with effect from 22/7/2005 and pay areas of salary and also make payment of pension to the petitioner. Full stop. The materials on record show that the petitioner herein was initially appointed as a master roll worker on 1/8/1993. This aspect can be seen from a certificate issued after his retirement by the executive engineer of the Inland Water Transport Division, dated 24/10/2025. Be that as it may, the petitioner, in view of the judgment passed by the learned division bench in the case of Upendas versus State of Assam versus Upendas, reported in so and so, had received the minimum of the scale of pay scale in terms minimum of the scale. First, the petitioner attained superannuated on 31/12/2024. First, thereupon, on 22/10/2025, the petitioner submitted a representation to provide him gratuity full stop. And pensionary benefits. The same having not been considered, the petitioner has approached this court by filing the present writ petition. Seeking the reliefs as above aforestated. Full stop. The materials on record show that various master roll workers who were engaged prior to 1/4/1993 and who were still working as on 7th of October 2005 were regularized with effect from 22/7/2005. it is the very case of the petitioner that the petitioner missed the bus, having been appointed on 1993. Full stop. The petitioner thereupon did not challenge the decision to regularize those persons who were appointed, who were decision of regularization of those persons on the basis of the cutoff date. Full stop. The petitioner continued to render service. It is also seen that during the lifetime of the petitioner never sought for regularization. Full stop. It is only post his retirement that too the petitioner has sought for regularization, and thereupon that too giving effect from 22/7/2005, so that the petitioner gets his pensionary dues. There is one judgment from of the Supreme Court. What is the name? I forgot. It was it went from Nagaland. What was the name? Hey, Nagaland to judgment to the Asana. To ki asil naam to?
Ashumi or something.
Angami. Huh?
Some Ashumi or something. His wife.
Angami, Angami.
And
That is a judgment passed by Justice M.R. Shah and all. What has happened? The division bench out here directed regularization 1 day prior to his, because there you don't have the period of service. Pensionable period of service is not there. And Angami or it was a both judgment to
but
the
another judgment is there. It was also from Nagaland, wherein Supreme Court said no, no supernumerary post can be created for the purpose of regular.
No, that is the case where it is the wife who sought for.
Yes, Asumi, some Asumi.
Atsumi, yes,
Yes.
and Atsumi or
And
something.
Asumi or something.
Atsumi.
I can furnish that judgment.
Etu likhi dibe na. Ki likhi tu? Yeah, pustu. In this regard, this court finds it relevant to refer to the judgment of the Supreme Court in the case of so and so, wherein the Supreme Court held as under. Itu Atsumi hai case. This court also takes note of that various temporary as well as master role workers, casual as well as master role workers, had approached this court seeking regularization. However, in the judgment in the case of Upenda Supra, the Supreme Court, the learned division bench of this court have rejected the same by an order dated 1/8/2017. With a further direction that those persons who have worked 10 years prior to 1/8/2017 would be entitled to the minimum scale of pay. The petitioner have also received the said, as is admitted in paragraph number 2 of the writ petition. Taking into account the above, it is the opinion of this court that the petitioner, having approached this court only after his retirement, the instant writ petition cannot be maintained in view of the aforesaid analysis. Accordingly, this court does not find the present case to be a fit case for issuance of notice for which the writ petition stands dismissed.
Just one thing, Lordship, here the petitioner is before your Lordship and he is alive, Lordship.
Huh?
The petitioner is before the Lordship.
So what?
Now, somewhere I heard Lordship said during his lifetime.
During his service, whatever, that will be corrected. But I think it is N. Achumi.
And Asumi Lordship, wife approached the court,
Huh?
Lord. It was the wife, Lordship.
Understood.
Yes.
But there also, it has also been mentioned that he, during his service career, did not.
Yes, that
approach.
particular line
That is
was-
the paragraph used by the Supreme Court.
Yes,
During his lifetime, during his service career, he never approached.
yes, that was there, Lord.
Family pension for divorced daughter. Her father was an employee paid anyway. The after retirement, he received pension. And after his death, her mother received pension. And during though she was married, but she was separated during the lifetime of her mother. She was dependent upon.
So you got the decree on 12/3/2025.
Yes.
So you are right for pension only after 12/3/2025.
The memorandum, office memorandum at page 49 says that if the divorce suit is instituted during the lifetime of the pensioner,
Where?
at page 49.
What does it say? In case of a widowed daughter, yeah, where is it?
Paragraph, subpara 5 of the paragraph 2.
In case of a widowed daughter, death of her husband, and in case of a divorce, that her divorce took place during the lifetime of the government servant or pensioner or his or her spouse. However, family pension shall be payable to a divorced daughter from the date of divorce. If the divorce proceedings were filed in a competent court during the lifetime of the government servant or pensioner or his spouse, but a divorce took place after their death, in such a cases, if consequent upon the death of the imam, pensioner or spouse, the family pensioner area that has become payable before the date of the divorce, the family pension to such divorce shall not be commenced before the aforesaid member ceases to be here. Now, this line doesn't help you, but you will be only entitled post your divorce.
Yes, that is all right. Yeah.
Yes. So this happened only on 12/3/2025. When did you apply?
It's a representative.
And why nobody is appearing for the union today? Are they on strike? Huh? Are the union on strike? Where is the DYSGI? Hey, Mati, put here, DYSGI.
Yes, Lordship.
Are these matters not there of the union?
Yes, Lordship.
They-
I am.
When did you file the application? When did you inform about the death?
2/5/25.
Huh?
2/5/25.
Where is your application?
Page 34.
Page?
30.
34 is the decree. This is an application. What is the date? When was it received? Where is it? Received? Where is your receipt? That this application was at all submitted. Obviously, this is not the application.
No receipt there.
Then how do you know that you filed the application? And why haven't you enclosed the divorce decree? You were married in 2002. How will these people know?
Decree there in the.
Huh?
Decree is there.
Enclosed as death certificate and pension book. Where's the decree?
But it's not enclosed with the.
Why haven't you enclosed? Isn't it the most important thing?
Yes.
Then go and file an application and properly and come. You don't come like this.
There's mention of the case number.
No, so what? At the time when your mother got it, you were not eligible. Your mother got it.
Yeah.
But prior to that, when your mother was getting till 2015, you were married. You were married. The divorce only happened on March 2025. You apply, no date. There's no date of receipt.
There is no proof of receipt, but I have.
You have not even enclosed the date of decree.
Yes.
Then
But
what
the-
type of
the
application are you are
details
coming
about
before this
the-
court?
Details about the judgment has been given.
So what? You go there. File a proper application and then if it is not given, then you come, isn't it?
Yes.
Bring to the notice about that, what you have filed in the writ petition, go there properly. You don't come like this. Not a case for issue. You have a good case, but why should do this fourth issue a writ in the nature of mandamus today? Without properly applying. Where's your receipt? Heard Mr. O. Losco, the learned counsel appearing on behalf of the petitioner.
Your
Which-
lordship can keep the petition pending. and you can
Absolutely
invite-
no.
by the-
No. To say later on the matter has become infructuous. Tell me, you want to put something on their, a guillotine on their head and say that there is a writ pending against you, kindly do it as fast as possible.
Otherwise, I am entitled, my, this is. political-
You are entitled, go there. Who has asked you not to go? Heard Mr. O. Losco, the learned counsel appearing on behalf of the petitioner. Ms. S. Bulwa appears on behalf of the respondents. The petitioner herein is aggrieved by the delay in finalization of the family pension to which the petitioner is entitled to, being a dependent divorced daughter of the deceased pensioner. In terms with the office memorandum dated 26/10/2022. Full stop. The materials on record show that the petitioner's father, Arun Pada Chakraborty, since deceased, during his lifetime, was
Commercial head class.
getting pension until his death on 11/7/2008. Thereupon the petitioner's mother received the family pension until her date on 28/10/2020. It is the further case of the petitioner that in the meantime, on account of marital dispute between the petitioner and her husband, a divorce proceedings was initiated, being title suit divorce number 43/2002, wherein a decree was passed on 12/3/2025. Thereupon, the petitioner applied for the family pension in terms with the office memorandum dated 26/10/2022. However, the same having not been accorded till date, the writ petition was filed. This court have duly inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner had submitted a representation, and if so, the date of the receipt of the said representation. And if so, the receipt thereof by the concerned respondent authorities. This court, Mr. O. Losco has drawn the attention of this court to Annexure 3. Rina,
Annexure 5, the dependent motion.
Annexure 5. However, a perusal of Annexure 5 does not show that there is any receipt of the applicant's representation submitted by the petitioner dated 2/5/2025. This court also taking into account the enclosures also do not find that the decree of divorce have also been placed before the concerned authority, which is the most fundamental document to be placed for the purpose of grant of family pension in terms with the office memorandum dated 26/10/2022. Considering the above, this court therefore is not inclined to entertain the instant writ petition. Accordingly, the writ petition stands dismissed. Be it as it may, this court, however, observed that the petitioner would be at liberty to submit a representation claiming family pension in terms with the office memorandum dated so and so, along with the necessary documents which would entitle the petitioner to the family pension. It is further observed that in the circumstance such representation is submitted, the concerned authorities in the NF Railway, more particularly, who is it? Respond number 3.
The 5,
Respond number
3 and 5.
3. 3 shall do the needful in terms with the office memorandum dated 26/10/2022.
Within 60 days from the date.
Within?
60 days from the date.
Why?
If it is not time limit, they will keep it.
Within 90 days from the date of submission of such representation. Preferably within 90 days, preferably. Yes, what is this?
Petitioners were engaged by the hospital management committee where they are still rendering justice.
You are still working.
Yes, doctor.
What do you want now?
There is a judgment of failure judgment lordship under the this says the similar situated workers lordship. Under that clause we cover lordship and regarding that lordship similar cases were also put up.
Don't go by similar cases pending. I have the habit of passing an order so that my order becomes the similar order to be shown. Yes. Now therefore tell me, what is your case?
Rather than lordship, the
You are there are 17 people.
here, 11, 11,
And
from 3 districts lordship.
you are getting the minimum scale of pay.
No lordship. This is our priority.
My lord, that hospital management committee is not a party here. They are not direct, my lord, engaged by the government. It is by the committees.
Lordship, what happened?
So they will have to, my lord,
A
if they can
medical
provide
officer-
from their own fund, my lord, of course, the government will have no objection.
Huh?
If they provide the, my lord, have the necessary, my lord, resources to, my lord, provide the minimum pay scale,
Lordship, page number 77.
then
lordship.
probably government will have no issue.
Page number 7.
What do you
liability
want
cannot
at
be-
No, what do you want, Mr. Counsel? What is your prayer?
Lordship,
Reasonable permanent engagement with at least the minimum pay and other benefits which are applicable to the petitioner and enlist them in the scheme and regularize the services of AR with consequential benefits. And for how many years you were working?
Lordship, almost 2 decades, Lordship. Almost 2 decades.
Huh?
Lordship. Page number 77, Lordship, and extra 26, Lordship. But of late-
Page 77,
Lordship.
Annex 86.
Lordship,
Wait. Yes.
there are 2 and there are 3, Lordship, 11, Lordship.
The departmentally related standing committee observed that the grants are insufficient for in respect of wages of cleaning, sweepers, etc. were engaged by the hospital. In this connection, you are requested to furnish detailed status as per the format so and so. The departmentally related clearing also observed the shortage of number of beds and so and so. Now your names are there.
Lordship. Time to time, Lordship, authorities has.
Format for submission of data.
Here list, some of the.
Wow, what are
department
these?
is there.
List of employees under Hotel Hospital Management Committee, Kamrup.
Lordship.
Your names are here,
Yes, Lordship.
all grade 4. What are you working as?
Different purpose, Lordship, some petitioners who has, all are in the fourth grade category. Some do work, as sweeper, some staff who get beyond Lordship. some-
But how do you take care? You see, that is the problem in filing so many petitioners together. Sweepers, there is a policy decision, it is to be outsourced. They
all-
can't be regularized.
My lord, in case of my lord, health department, medical colleges and my lord, hospitals, it is permissible. Only one exception, only for the hospitals.
Oh.
Regular sweepers are there,
Some are.
as per their notification, my lord.
Mr. Gautam Vaishya, have you noted that? Have you noted what Mr. B. Gogoi has said it?
In their
That
notification.
for health department, there is an exception for sweepers.
For hospitals, my lord, not health department, for hospitals.
Hospitals. So take note of that. When a case comes of sweeper, there are many cases of sweeper seeking regularization. And remind me. Anyway, so what do you want now? You are not getting the minimum scale of
Yes,
pay.
Lordship. My share is Lordship.
Okay. For after working for more than 10 years.
Yes, Lordship. Initially, Lordship, government has taken initiative, but still we are not getting the benefit, Lordship.
This is a document prepared when, Mr. Council?
By the joint directors, Lordship.
When? List of year prepared when? This was done in 2017 or 2020?
It is some list, Lordship.
2020. Well,
Recently they have
We
taken
do
another-
one thing, we issue notice in this case
My lord.
as to whether the petitioners herein are entitled to
Yes.
the minimum scale of pay in terms of Upendas. Issue notice making it returnable on 16th of March 2026. You have not made the hospital
They
management
are
the
not
party.
party.
Lordship, what when I had made the medical officer, he is the head of the concerned medical.
Where?
Lordship, the-
You have made so many people a party unnecessarily,
Yes, Lordship.
but you
Whatever
have made the
Lordship.
hospital management where?
Lordship, the post of secretary is held by the medical officer, Lordship, who is the, somewhere it is the senior medical officer.
And why you are making number 4, Gozendra Chandra Bora, a party?
By name কাটি দিও, respondent 4. Respondent 4, 6.
Lordship, this is the name of the medical, Lordship.
Oh,
Gozendra Chandra Bora is
mini
a
PSC.
medical.
Name of-
Lordship, name of the medical, Lordship.
Okay, but why you are not making the hospital management committee a party? Society
What
management?
happened, Lordship? The superintendent or the medical.
Are
officer-
you not working under them?
Yes, we are working under them.
So make them a party. Make them a party.
Lordship, I am submitting, Lordship, the medical officer who holds the post of secretary, Lordship, of that hospital management committee, Lordship. I had made the medical officer party, Lordship.
But not in the capacity of secretary, my lord. You'll have to be made, my lord. Then you can, my lord. This party.
Anyways, who is going to make the payment of the, who pays the salary to you?
Lordship, the hospital management committee.
Then how can we pass a direction if you don't do that? And therefore, there are, for each person, there will be different hospital management committee. Then if it was one party also, I could have made one. If it is 17, it is impossible. Wait, these medical and health officers are of these dispensaries have been made a party.
Yes, sir.
And you say that they are also the secretary.
Yes.
You do one thing. You file a fresh memo of parties.
Amended, Lordship.
fresh memo of parties, whereby, just for example, respond number 9, the medical officer of so-and-so MPHC, Bongaigaon. Have a look at it. It is not for you to see. Have a look at it.
Page 7.
Trying to help you out, then also it is not make sense. The medical officer of so-and-so, he will also be a secretary. So you do one thing, put medical officer and secretary of so-and-so, okay? And file a fresh memo of parties. Then on this, we can proceed. Okay? Then when you are making a reference to respond number 9, then it will go as per that. Okay?
I will get the.
You do one thing, we'll have it on 11th. You in the meantime file the fresh memo of parties.
Can it be after 20, Lordship? I have to take some instructions of them. If in some other committees, if secretary is different, then I will make them.
Okay,
participate.
Mr. B. Gogoi, appearing on behalf of the petitioner, on behalf of the respondents, submits that the petitioners herein are paid salary by the hospital, by the concerned hospital management committee. But these hospital management committees have not been made parties. Mr. So-and-so, who appears on behalf of the petitioner, submits that a concerned medical officer of the medical officer is also the secretary of the concerned hospital management committee.
Some of the.
What's some again now you are?
Somewhere I found that.
No, Mr. Counsel, you, then I can't help you. Without making them, you can't, I pass through.
I will make them parties. Lordship.
Okay. It's also the, yeah, now, is it some or not? Then if you have to make fresh one, then you have to file an IA. What do you want? Okay,
File an amended petition making them parties. Lordship.
okay, ठीक है. Mr. So-and-so is here.
Amended-
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner therefore sought for adjournment so that the petitioner can file appropriate application. Taking into account the above, list the matter upon such application is filed. For airing the concerned hospital management committees as parties to the instrument petition.
Okay.
I got it. It will actually. Yes, Mr. Naik, got it. Missy V. Achumi. Here you see this paragraph. At the time, paragraph 4.1, at the time of the death of the AI, he is not entitled to regularization as he was much below in the list of work charge employees whose services were to be regularized. Under the regularization policy, the services of the work charge employees were required to be regularized as per the seniority and as and when vacancy arises. The service of the work charge employees, even who were senior to the deceased employees, were regularized in a year after the death of Iman. Despite the above, the High Court had directed the state to regularize the services of the deceased here 1 day prior to his death, which otherwise his service were not required to be regularized as his turn had not come. Bench as well as there is hereby quashed.
Like in our case, Lordship, 2012, we issued a notification, Finance Department. We took a decision, no further regularization and no further creation of supernumerary posts. That notification came under silence. That was initially, I mean,
This led to the Upendas.
yes. Lord. So it starts from there only, Lordship. That notification of 2000.
Okay, I'll make the necessary changes. quickly.
If the petitioner was my lord suspended from his service as a lot mandal on 1/2/22, my lord. And what happened thereafter, my lord, on 3/6/22, the inquiry officer and the presenting officer were appointed for submitting a report within 2 months. But still date, my lord, the my proceeding is not, my lord, proceeded, my lord. It is no memorandum of charges is submitted, issued to the petition. No, my lord.
You have
no-
retired in
Suppose
the
was
meantime.
issued.
Yes, my lord. On the very next year, next month he retired on March
March 2000,
22, my
you retired.
retired.
And till date, no memorandum of charge issued.
Not, my lord, no.
And in fact, there is also a,
Earlier approved reasonable court and they are saying the provisional.
you retired on,
31/3/22, my lord.
you see, as on 6/4/2024, they are yet to finalize who is going to initiate the departmental inquiry. Now tell me, in view of Rule 21, can you initiate a departmental inquiry?
That I have to take instruction, Lordship. That I have to take instruction, Lordship.
What instruction?
Lordship,
That, are you going to take instruction from your officer as regards the applicability
no,
of
no,
rule?
no, Lordship. Le-
Kindly come to page 47. No. Kindly come to page 47.
yes,
Materials on record. This is the third time the petitioner has come,
Yes,
Yes.
isn't it?
Yes, my lord.
Second,
Pardon.
third.
47, yes.
Kindly come to page 47. See the paragraph. The aforesaid LR staff are belongs to state cadres as per the final publication of the gradation list by the so and so. Read it. As such, the department may be initiated by the Revenue and Disaster Management.
Yes.
What
that-
is the date? 6/4/2024.
Yes, Lordship.
What is there then?
That will, I think until that date, no.
He has retired in 2022.
Yes.
He retired on 2022. That is notification regarding the man of that state cadre and the district cadre. It will come on 3/11/2023.
I'm not on that. Rule 21 says that you cannot initiate the departmental proceedings after he has retired.
24 is there, Lordship. 24 pension rules, Lordship.
Huh?
24 pension rules, Lordship.
24 is what?
1969, Lordship.
Then
That
what does he say?
Within four years, Lordship.
This is with the special sanction of the governor.
Yes, the Governor,
You
Lordship.
have not taken the sanction of the governor, then how can you stop his finalization of his pension? 24 says something else.
Governor, yes.
24 says about removal. Once he is removed, he won't be getting a pension. That is 24. But 21 says that look here, if during his lifetime there is no judicial proceedings or any departmental inquiry, you cannot have it after his year unless the governor grants the sanction on the section, the
No,
proviso.
There
Where
is
is the
a,
governor's sanction?
yes, there is a process, one criminal case was registered,
So what?
but
Criminal case has been registered, has the charge sheet been given?
that's why, Lordship, the
Hey, go on, Dixon.
instruction is necessary, Lordship.
Because this earlier on, when the matter came up before this court in 2023, a submission was made that look here, we are having the departmental proceedings and we are going to finish it off. Initially, you initiated the departmental proceedings
Yes, after,
by appointing an inquiry officer, even asking him to submit his reply,
Lordship.
didn't it?
Yes, sir.
Then no case. Let us see 2000 section 21. Twenty-one says the governor reserves the right to himself withholding or withdrawing the pension or any of that, whether permanently or a specified period, and the right of ordering the recovery from pension of the whole or any part of year if in a departmental or judicial proceedings, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered under re-employment after retirement. Such if instituted while the officer is in service, whether before, provided that before his retirement or during a year shall after the retirement of a year be deemed to be a proceedings under so and so. As of now, you don't have that proceeding. Now let us come to the judicial proceeding. You have a right to withhold as per the judicial proceeding,
Proceeding, yes.
but not as regards
Yes,
a
Lordship, yes,
departmental.
that's what-
Departmental is
That's
over.
why I am saying the instruction.
Now see, such department if is not instituted while shall not be instituted save with a year within 4 from the date of, shall not be in respect of an event which took place more than 4 years ago. So
Yes.
even the governor as of now cannot do so, taking into account that 4 years have passed. Date of the incident was on 29/1/2022. So there cannot be a departmental proceedings as of date. Even the governor can't help you.
Yes. Now, Lordship, regarding the criminal pendency of the criminal case.
Okay. Now let us see 22.
Yes.
Where in any departmental or judicial is instituted under 21, or where a departmental proceeding is continued under Iman or Iman against an officer who had retired on attaining the age of compulsory return or otherwise, he shall be paid during the commencing from the date of retirement to the date of conveyance. Final orders are passed of provisional pension, not exceeding the maximum pension which would have been paid so and so. Or if he is under suspension on the date of retirement of the agreement of provision under a year shall be adjusted against the final retirement sanction and so and so. Now, is there a criminal case pending?
Well, we have not received any summons, well, till date, well. Whether charge sheet is submitted or not, no summons received well, till date.
So what happened to the Doboka PS case number
Yes.
13/2022?
Sir, he is from the bail, he has not received any summons, well, we do not know whether charge sheet is submitted, sir. No, well.
So you have not made an inquiry because the only thing now is on that.
Yes.
So without making an inquiry, you have approached this court. How can this court pass an order? It makes no sense. Because in view, if there is a judicial proceedings pending
Yes.
in respect to an incident which happened prior to that,
Yes.
and more particularly those judicial proceedings was happening prior to this, huh?
Yes. 22, Lordship, it is of the,
And the right of ordering a recovery if in a judicial or a year, the petitioner is found guilty of misconduct or negligence. So this including service on the year. So these judicial proceedings
Otherwise, well,
has to be pending.
yes, otherwise, well, departmental proceeding.
The departmental proceeding is gone. Finished, no way. Because you see page 47, they are yet to initiate.
yes.
But as regards judicial proceedings, they have a case.
Lordship, may kindly see page 21. Lordship, this is an order by which Lordship, enquiry officer and
That
presiding.
is why this was set aside.
Court
I'm
has
saying
set aside-
therefore, what has
No,
happened?
That is, Lordship, it was initiated, subsequently who will be the authority that arose, that question.
No, you see, this was there, but this was set aside.
Yes, Lordship, I
Now
understand.
kindly see, therefore, kindly come to page 47.
Now, if yes, that I have seen, Lordship. If Lordship comes to the prayer, Lordship,
Of?
prayer, page 15. Lordship, he is praying to conclude the departmental proceeding initiated against the petitioner on 1/2/2022. So that is during his service period. Within a stipulated period.
You were the lot mandal.
Yes, well, what mandal.
Now who is your appointing authority?
Appointed deputy commissioner. Deputy. The deputy commissioner was directed, my lord, as page 45 by the deputy secretary, page 45, my lord.
With reference to the manual order passed by so and so, the department is advised to conclude and dispose of the departmental procedure drawn up against the delinquent as per so and so if the charge is approved, he is informed
That
that
will
the
helpful.
incumbent will be paid pension as per the outcome of the DP until the DP is disposed of, he will be, department is suggested to take action. Now that is okay. Now thereafter you kindly see page 46.
That's the retired one. 51, 3 retired for you. এটার আমি concern না। এটা মানে সকল আপনাদের মধ্যে।
Now, the district commissioner
Yes.
who initiated says that the department may be initiated by the revenue department.
No, that was subsequent, Lordship, that Lordship regarding, originally, Lordship, Lart Mondal, the proceed, the appointing authority was deputy commissioner. But subsequently, Lordship, regarding the departmental proceeding, which are pending, in the deputy commissioner, was it that way?
Have you appointed
transferred.
an inquiry officer?
Lordship?
Have you appointed an inquiry officer thereafter, after my order?
No, Lordship, that I have to take instruction.
You have not appointed any inquiry officer thereafter. So therefore, if you now say that the deputy commissioner cannot make a year, so therefore the very initiation has gone for a 6. Be that as it may, but the petitioner has a problem as regards the judicial proceedings, whether there is a judicial proceedings or not.
It is Doboka
You
PS
should have inquired. What has happened to the Daboka PS case?
My lord, as per the page.
They say that it has gone to the enforcement directorate,
As per page 46.
the state ED.
Page 46 was last.
Lordship,
one, sir.
it is.
That the PS case is transferred to the vigilance department.
Ah, that
But
is
so
why
far-
I'm saying the state ED.
From vigilance department, we have not, my lord, any communication made, my lord, whether to recording a statement or anything.
That's why, Lordship,
Or I can take instruction regarding.
Anyways, we'll obtain instruction from them. Let me come back.
এটা criminal case তো রয়ে যাবো, no?
Let me come back.
25 না এটা তো এটা রবো এটা ক্রিমিনাল কেস তো করে যাবো
Petition order, the lordship's order is there. That petition challenging the 3/6/22 order appointing the president of the inquiry officer. That petition was not pressed ultimately.
it was withdrawal.
And your lordship did not interfere with that. Page number, my lord.
44
44. 43. This is going on withdrawal. And that challenge, that was not pressed, my lord. Page number 43, paragraph 2.
The question is this particular document at page 48.
48. But Lordship, in page 25, it is translated copy is 24.
Now, if you have not submitted a charge sheet in respect to the Boca PS as of today,
That he will.
that cannot be a judicial proceedings.
Lordship.
To be a judicial proceedings, it has to be before a court.
Yes, sir. Before, it is after submitting the charge sheet, Lordship. Charge sheet must be submitted. Lordship.
Then only things will happen.
But in page number 24, Lordship, can you see?
Understood?
Yes.
But page 47 says something else.
Fo-
The very
46
deputy district commissioner says that now the initiation should not be made by him. He himself questions his authority for initiation.
Lordship, as he was the cadre of the state cadre, Lordship, it is belong to the LR, Lordship. Therefore, on the new circumstances, as this department proceeding may be initiated. Lordship, I think the language may be some, because Lordship, in the earlier Lordship, in page
He
24,
initiated.
page 24, he called for hearing, Lordship. After appointment of the inquiry officer, Lordship, he was called for hearing. No, no, no.
February.
No, it is June 3rd. Yes. No, it was on 27/7/2024. It means after appointment of the inquiry officer. It is page 21. Page 21 is on 3 June 2024.
When were you called for?
It is page 24, Lordship. It was
That I understand.
27/7.
27 is different. You see, if you see rule 9.3 say, 9.2 say, you are going to give him a memorandum of charge.
Lordship.
After the memorandum of charge, you are going to, that is the initiation.
Lordship. But
Then he may submit a reply.
yes, Lordship.
Now,
Yes.
here in the case, what you have done, you have appointed an inquiry officer and said that disciplinary proceedings is being initiated, so and so.
But without the submission of the so cause, the statement of allegation, I think in between, Lordship,
So therefore, now the very deputy commissioner who initiated,
Lordship.
rightly or wrongly, that was, in fact, that is why I granted a stay to him. At that point of time, there was some order being passed by me, you know. Kindly see this order.
44, Lordship. It was disposed on withdrawal, Lordship.
There is a 44. Made clear that withdrawal of the permanent figure in the departmental.
Kindly come to page 38. The case of the petitioner herein is that the department was initiated against the petitioner at the time when the petitioner was in service. At that relevant point, the petitioner was also suspended. Pursuant thereto, it reveals from the record that an office order dated remand, an inquiry officer as well as the presenting officer was appointed. It is however submitted by the learned counsel for the petitioner that as on date there is no memorandum of charge basis. The learned counsel submitted that so and so. That without a memorandum of charge as well as the statement being submitted, the question of appointment of an inquiry officer as a present does not arise. It is the further case of that in the meantime, the petitioner has already retired and he has no further information as to whether the development has been continued in terms with so and so. The learned counsel therefore so and so. So therefore, as of now, you have not issued the memorandum of charge.
That's right.
And now at page 47, the very district commissioner says that look here, it would be proper on the part of the revenue department to do so.
Lordship.
So
Yes, yes.
therefore, very initiation is on the basis of not an initiation cannot be made by appointing an inquiry officer. Initiation as per rule 9.2 is on the basis of a statement of allegation, which admittedly it is not
No.
there.
That's
But subsequently, it is being said that it will be completed, therefore the matter was withdrawn. You see, kindly see, paragraph page 43. That though a challenge is to be made as well as the petitioner was appointed in so and so, but he has no insight to press the email, the president so and so, petitioner is not receiving here. Submits the petitioner is presently being paid, however, a final pension could not be processed in due to the remand, which subsequently was transferred to the vigilance. In that regard, he has placed a record of instruction. So and so therefore submits that the petitioner is presently receiving the remand, he would not learn concern, taking into account the above, made clear that the withdrawal of heir shall not prejudice to an heir as well as the right of the heir to the final pension in future if so entitled. This order was passed in the year 2023.
yes.
But the question is whether you have initiated thereupon submitted the memorandum of charge. One. And that as on that day, they were not. So there is no initiation.
Maybe
But anyways,
in
we will
criminal case now.
we'll seek
and
instruction as to whether there is any judicial proceedings pending.
It means charge sheet submitted or not. Yes.
Ah.
Charge sheet.
No, judicial proceedings pending as on date. If not, then he will be entitled to.
No.
If no charge sheet is submitted, he will be entitled to.
Yes.
Then it will be, it's a question of recovery
Lords.
as per 21. Issue notice making it returnable on 23rd of February 2026. Mr.
Lordship.
J. Hendrick accepts notice on behalf of the respondent number 1 and 4. Mr. P. Nayak accepts notice on behalf of the respondent number 2. Mr. J. K. Gusami accepts notice on behalf of the respondent number
5 to 10, Lordship.
5 to 10.
Lordship.
The grievance of the petitioner, extra copies of the writ petition be furnished during the course of the day. The grievance of the petitioner herein is that the petitioner have not been, petitioner's pension have not yet been finalized. In that regard, the learned counsel appearing on behalf of the petitioner had submitted that though a Doboka PS case number 43/2022 was initiated against the petitioner, have been registered against the petitioner. But it is not known till date as to whether any charge sheet has been submitted, and a matter is pending before the court to come within the ambit of a judicial proceedings. The learned counsel appearing on behalf of the petitioner further submits that though on 3rd of June 2022, an office order was issued by the Deputy Commissioner, Hojai Sankardev Nagar, that a departmental proceedings have been initiated against him by appointment of an inquiry officer as well as a presenting officer. But taking into account the provisions of Rule 9 of the Assam's Discipline and Appeal, Assam Services Discipline and Appeal Rules 1964, the learned counsel appearing on behalf of the petitioner submits that since a memorandum of charge having been issued in terms of Rule 9(2), the said cannot under any circumstances be said to be a departmental proceedings. The learned counsel for the petitioner further referring to the communication issued by the district commissioner, Hojai, dated 6/4/2024, further submitted that from a perusal of the very document, it is apparent that the investigation in respect to Doboka PS case number 43/2022 is yet to be over. He further submitted that the very deputy commissioner, Hojai, who have sought to initiate a departmental proceedings on the basis of the communication dated 3/6/2022, had itself doubted as to whether there was any initiation, and it is under such circumstances mentioned in the said communication that the departmental proceedings may be initiated by the Revenue and Disaster Management Department of the Government of Assam, taking into account that the land revenue staff belongs to the state cadres. The learned counsel therefore submits that in view of the fact that there is no judicial proceedings or any departmental proceedings initiated, the petitioner is entitled to the finalization of his pension forthwith. Mr. J.K. Gusami, the learned counsel appearing on behalf of the petitioner, submits, respondents 5 to 10 submits that he will obtain instructions as to whether any judicial proceedings presently is pending pursuant to the Boca PS case number 43/2022.
Now he's submitted that it was transferred to the vigilance.
After investigation, charge sheet has to be submitted, then it will be pending in the court.
Lordship.
You obtain that instruction. And further, as to when departmental proceedings have been initiated pursuant to the communication dated 6/4/2024, or as to whether the departmental proceedings which was initiated on the basis of the communication order dated 3/6/2022 have been continued. The said aspect be brought on the said instructions be brought on record by way of an affidavit to be filed before this court. Next day to get a go, sir. 23, na? On or before 22/2026. Mr. J. Hendrick also, the Learned Standing Counsel appearing on behalf of the Revenue Department also shall initiate, inform this court as to whether, or shall also obtain instruction as to whether any departmental proceedings have been initiated by the Revenue Department against the petitioner on the basis of the communication dated 6/4/2024.
23.
Was declared on 31/12/2020 law. That on 18/2/2022, my lord, the original pension was granted law. Thereafter, it is not finalized lordship. My lord, after retirement, my lord, the FIR was, my lord, lost. In that case, petitioner's name was here lordship. And in that case, he was on.
So there is no departmental proceeding.
My lord, no departmental proceeding.
And crime branch PS case number 486/2021 is under investigation.
No charge sheet.
Is under investigation. Is the same like the earlier
Yes,
thing.
lord. Now, it is.
Issue notice making it returnable on 2nd of March 2026. Mr. J. Hendrick accepts notice on behalf of the respondent number 1. Mr. P. Naik accepts notice on behalf of the respondent number 2 and 2. Mr. B. Sharma accepts notice on behalf of the respondent number 3. You are 1 and 4, na? 1 and 4. Miss S. Burwa accepts notice on behalf of the respondent number 5 and 6. As all the respondents are duly represented, extra copies of the petition be furnished during the course of the day. The grievance of the petitioner herein is that the petitioner who had retired on 31/12/2020, though have been provided with the provisional pension, but his final pension, but the petitioner's final pension have not yet been finalized, though there is no departmental proceedings or any judicial proceedings. It is the case of the petitioner that the petitioner, though, was it is a case of the petitioner that though a criminal case was registered against the petitioner as crime branch PS case number 486/2021, the said investigation is presently ongoing. And therefore it is submitted that as no charge sheet, as there is no judicial proceedings, the question of not finalization of the petitioner, a pension of the petitioner does not arise. In view of Rule 21/22 of the Assam Services Pension Rules 1969. The learned counsel further, for the petitioner further submits that there is no departmental proceedings also against the petitioner. Mr. Miss Espurva, who accepts notice on behalf of, who have accepted notice on behalf of the respondent number
5 and 6.
5 and 6, shall obtain instructions as to whether any departmental proceedings are pending against the petitioner. And further, as to whether any judicial proceedings is pending, as well as also whether there is any judicial proceedings pending in connection with Crime Branch PS case number 486/2021, registered under section 420, 406, 294, 417 of the IPC. The said instructions be brought on record by filing an affidavit on or before 27/2/2026. You will come later on.
Sorry, Lordship, one mistake is here, Lordship. My lord, actually that is in a piece, my lord, is some wrong, my lord, case number, Lordship. Actually, case number, Crime Branch case number was 08/2020.
Huh?
8 of 2020.
8 of 02/22. No, Sailu, you have enclosed the FIR.
Yes, Lordship, order is there and FIR is also here.
Sailu.
8 of 2020. All right. Make reason. Participated in the recruitment process, my lord, but initially he was declared unqualified in the height measurement. Subsequently, my lord, he filed appeal, my lord, as per order of this court, my lord, and in the remeasurement, he was declared qualified. Thereafter, medical also done, my lord, and he was declared fit, my lord. But his result has been kept neutral, my lord.
Not you have to obtain the instruction in it.
Where withheld?
Last page number, my lord, 65, my lord.
Hmm?
Page number 65, last
60?
5.
Constable of Armed Forces withheld.
So, what?
When was the result announced?
15, 15-1.
15/1/2020.
Then did you approach them and ask them why? Is this a information center?
But-
Huh, Mr. Roy?
Not you.
Doesn't it appears that this, the petitioner have treated this court as an information center,
Lordship.
inquiry center?
It is not declared fit by the review medical.
Understood. It has been withheld, not rejected.
Yes.
Withheld maybe for some reason must be there. That have you inquired with them
No, directly approach.
or directly approach this court? Inquire and find out. You can't allow this.
Not you.
Then we do it liberty.
Huh?
We do it liberty of this.
Mr. H.R. Ahmed, the learning council, let me just put it down, okay? So that it may help you out. Heard Mr. H.R. Ahmed, the learned counsel appearing on behalf of the petitioner, Mr. S.S. Roy appears on behalf of all the respondents, isn't it?
Yes, all the response.
So this court takes up the instant writ petition for disposal at the motion stage itself. The case of the petitioner is that in pursuance to the notice dated 5/9/2024, the petitioner submitted its application for appointment in the Constable GD as Constable GD in the Central Armed Police Force and SSF, Central Armed Police Force. Pusto. The petitioner initially was found lacking in height, na? In the detail, in the PST,
PST.
PET or PST?
PST.
PST evaluation. However, the petitioner upon the directions passed by this court dated 19/9/2025 in WPC number 5456/2025, submitted an appeal, and it was found that the petitioner had the requisite height as per the advertisement. It is the further case of the petitioner that in the meantime, that the petitioner's medical examination was also conducted, wherein also the review medical board have opined that the petitioner was fit. The grievance of the petitioner is that in the results which were announced on 15/1/2026, the petitioner's name, roll number, and name has been kept in the category of withheld. And it is under such circumstances the petitioner has approached this court. This court inquired with the learned counsel appearing on behalf of the petitioners as to whether the petitioner had inquired with the respondents prior to approaching this court. The learned counsel, with all fairness, submitted that to his instruction, there was no such information sought for. Under such circumstances, this court therefore is not inclined to entertain the instant writ petition. And accordingly, at this stage, and accordingly, the writ petition therefore stands closed on being not entertained. This court, however, observes and directs that the non-entertaining of the instant writ petition by this court by the present order shall not preclude the petitioner to submit a representation before the concerned respondent authorities. And if such representation is filed within a period of 7 days from today, the concerned respondent authorities shall intimate the reasons within 30 days thereafter. It is observed that in the circumstance the petitioner is aggrieved by such communication, it shall be open to the petitioner to approach this court.
Was made by, he joined also. Because after joining, he was asked to submit that the police very close. The police they found there is a 490-day cases pending, that's where he is also one of the accused.
Where is your FIR or PRC case number?
Possible fact, take that in.
Charge sheet given, na? Let's see the charge sheet.
Doctor, kindly see what charge sheet is paid.
Who are you?
I am the brother of the husband of.
Page 44 for 30.
Your name is Insab
My
Ali.
name is Madam Dakshya. In Sabah. Possible fine. Tax is possible fine page 47. One operative part.
And what has happened to the proceedings thereafter? This was done in 2020?
Not yet further proceeded by tax sheet file under 498, 323. So far the criminal case is concerned. In the FIR, you have possible fine, husband is fine. Total 5% and all the family members are, father, mother, brothers. And he is one of the accused in that case. Tax sheet for the 498 FIR.
So basically, 498 my lord, almost all the family members, all the time it is over. My case is, my lord, I have given representation to them. If ultimately I am found guilty, already you discharge me. But now I am serving my lord since 2011 as home guard. During the service at home guard, I applied for that year. I got selected. I joined. Posting was given to me. Thereafter, they asked me, my lord, to submit the verification. That's why, madam, I am now not allowed to join my training.
Why you are not challenging this charge sheet? Taking into account, why I'm saying so?
Hmm.
It's a very vague charge sheet. You don't make a charge sheet like this. Something has to, isn't it the basis of a complaint, like a complaint? What has happened, what has not? Then we found everything and so and so. Right? These are criminal proceedings.
FIR name, they might have filed the charge sheet, FIR name like you.
Maybe, but charge sheet is very vague.
That is always open to challenge my. But my case. my
Because
case-
this has happened in the 6 years have passed by.
Yes.
Yeah.
So therefore, if you want to get the benefit, you
Now the question was that because ultimately conviction has not been there.
Hmm?
Charge sheet file, my lord, the trial has not yet started even, my lord. In that case, if I am found guilty, my lord,
Now, the problem is
think-
that it is also the mandate of the advertisement as well as that you have to give, you cannot have a case of moral turpitude. The allegation which is there is of moral turpitude. Although very vague, Mr. Chaudhary. Why not? Kindly, no, see the allegation.
yeah, I
The
have seen.
description of this case is so and so, that so and so forcefully entered her house, abused filthy language, it's okay, and physically assaulted and injured her. Accordingly, Gosaigaon so and so took up for investigation of the case. During investigation, place of occurrence was visited, information of the witness were recorded. After investigation, having found sufficient evidence against the accused person, so and so under 498A and 323. 323 is grievous hurt or simple hurt?
Simple.
Simple. So that is, may not be, yeah, but 498A. Now, recently I came across one judgment of the Supreme Court pertaining to this 498A. You can't rope these people unnecessarily.
Yeah, that is there, my lord.
Very recent judgment,
Yes,
2-3 days back. Yeah.
First you try to don't arrest the first time, my lord. That is the case.
So there it says that you cannot come like that.
So people observe matter sometime or family members ago. So
Mm.
that's why we. boss
We
law-
do one thing, Mr. Chaudhary, we can't allow you a petition in entirety today. We issue them notice and keep the post vacant.
Posted back and.
No, postage.
Understood, but they may fill it up if you don't do it. Now, if you don't do it, they may fill it up.
I have done the training.
Ah.
The training, they have said that it go and bring your certificate. They could have done it on their own.
But it is a mandate of that. I have found out earlier cases also. Where is it? You have
Actually,
joined?
it is Selection, they have posted me also, my lord.
Where?
The selectors, your lordship will find, pay, your lordship. Join, man, page 36, man, page 36. So lordship will find one of the place of posting, scale of pay, everything was given, page 13.
You have joined?
Yes, man.
But
37, page 37, you will kindly see, serial number 1751.
Now, where is your joining letter?
Already, my lord, your lordship will find. I have stated, I have joined up, your kindly said place of posting also.
Huh?
Place of page 38.
Now, where have you joined?
Yes, I have joined here AP 7th AP Battalion Kukhaya. He joined us 10-12, madam.
On 10-12. Where? When did you join?
Kukhaya.
Where is your joining letter?
Even posting given, so I have joined there. From there, they submitted the training. After joining,
No, here it is all, but when were you sent for training? Something is there, huh?
worship. Page 38, your worship is in page 37. My name, district, then my address, Name, post, date of place of posting.
So it came into light later on about the PRC case number 523.
Madam, because in the column, there is no column in the, but yeah, in the form. that-
Mm.
that is pending, madam, on the police verification.
Yes, police,
One police verification was, madam, called, then in that case, madam, they have informed the SP.
The above is subject to the final document verification and security vetting of selected individual. So your appointment is dependent on this.
But already joined, madam.
Well, joint is there, page on certain. Yes.
Subject to verification, so while during verifications, this was detected.
Okay, let them go ahead with the training,
Lordship.
but not to give him the posting is a different thing.
Page 34, Lordship.
Hmm.
It is Roman 12, no? Page 34, Lordship, Roman 12 rule, Lordship. 12, the final appointment of this 12, Lordship. The final appointment after selection is subject to the satisfactory police verification, report and final medical.
No, this is there and this is also there, not only here.
Yeah.
You see this appointment letter. Kindly come there, that is why I've looked into it.
Yes.
Kindly come number 8, page 38.
Page 30.
The above is subject to the final document verification and security vetting of the selected individual.
Lordship,
So this is conditional.
Lordship, conditional, Lordship.
But then also you have sent him to the training.
Training, Lordship, after disposal, we will send. After.
Wouldn't it be difficult?
Lordship,
As regards logistic, don't give him appointment. I'm not saying about appointment. Only as he's already there in the training.
no,
let
no,
him
he is
do
not
a-
in the training, Lordship.
Huh?
He is not in the training. He
He's
has
in
not
the
stand.
training. That is what he says in this affidavit, in this affidavit, yeah. Kindly see page
15 I have joined.
No, no.
51. 51, the second paragraph,
51.
the last line. I joined my service on so and so at 7th AP Battalion. Thereafter, the authority sent me
To the headquarters.
along with my similarly situated at so and so and so and so. The police authority of Iman informed me that during the process of police verification, it has come to know that there is a case of so and so pending against me, and as such, my police verification could not be, and therefore the authority asked me to clear the same.
Yes.
52.
But this is your final relief which you are asking.
Yes, that is the final.
And
That
this
is,
still-
If I allow you today without asking them, it will
Yes.
be, it's not an interim relief.
One thing, madam,
Let them obtain instructions.
yes, Lordship.
And help it.
whether I joined or not, madam, that will.
No,
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 whether the can be permitted to go ahead with the training.
training, yes, Lordship.
Let me obtain instructions. Because that is your final relief. See,
Fine.
kindly page 14. If I
Yeah.
grant you this, it will be allowing the repetition without giving
Yeah.
them.
I had seen my, but. No, madam, but allowed to till my disposal, my page 52, 51, madam.
Understood, but you see, the said to allow the petitioner to join the training.
Hmm.
That is the problem.
That is the final.
Because from the
final-
training, I was sent, madam, that's why.
Very well, but you see, this is subject police verifications. Anyway, let's see, issue notice making it returnable on 27 February,
Civil Lordship.
27 February 2026. Mr. J.K. Gusami accepts notice on behalf of all the respondents. Extra copies of the writ petition be furnished during the course of the day. The case of the petitioner herein is that in pursuance to selection process initiated for recruitment of 1645 post of constable UB, 2,300 post of constable AB in the Assam Police and 1 post of constable UB in the APRO. by the advertisement dated 6/10/2023. The petitioner was selected and the select list was published on 2/12/2025. The petitioner's name was selected uh, as a constable
AB.
AB. As a constable AB
Serial number 1751.
by the select list dated 2/12/2025. Where's the name?
Name page for 37,
Page?
page 37, my lord, second serial number 1751.
Ah. It is also seen from the very select list that the petitioner's place of posting was 7th APBN. Thoralik Hola, Kokrajhar. এই নামটো চাই ল'ব হা, page 37, number serial number 1751. Full. It is the further case of the petitioner that the petitioner, in terms with the select list, reported to the place of posting on 10/12/2025. And thereupon the petitioner was sent for basic training at the Nagaon Police Academy. Nagaon? No, at the Nagaon Training Center, Nagaon, on 15/12/2025. It is the further case of the petitioner that on 22/12/2025, when the petitioner was undergoing training, it was intimated that during police verification, it was found that there is a PRC case number 523/2022, which is pending before the court of the judicial magistrate, first class Gosaigaon. And therefore, the petitioner was asked to clear out that PRC case number 523/2022 and then join the training center. It is under such circumstances the petitioner have therefore have approached this court seeking appropriate relief that the petitioner should be permitted to complete his training. Full stop. Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondents, shall obtain necessary instructions in that regard and place it before this court by filing an affidavit on or before 25th of February 2026. On the aspect as to whether the petitioner can be permitted to undergo the training by taking appropriate undertakings from him and keeping the petitioner's appointment provisional. Yes, what are you doing on this side?
My lord, petitioner number 1 is the mother of petitioner number 2, my lord. And petitioner number 1 is the second wife of her late husband, my lord, who was a sergeant in Air Force. Earlier, my lord, her marriage was done on 2002. Thereafter, he expired, my lord, on 16/6/2017. Thereafter, one petition was filed in 2019, my lord. My lord, praying for pension. And in that case, my lord, Roshi may kindly come to page number 19. It was disposed. And operative on page number 20. Here, respondent authorities, my lord, has admitted that although petition number 1 is not eligible as a second wife, my lord, but her daughter and children are eligible, my lord, for pensions. Her children are eligible, my lord. Second wife children are eligible, the unmarried daughter, my lord, Thereafter, this, my lord, I'm reading the 40%. In view of the above, the present writ petition is disposed by directing the authorities to disburse the family pension to the children of the deceased as stated in the affidavit in opposition dated so and so after verification of the document that are required to be submitted by the petitioner within 15 days. Thereafter, my lord, lordship may kindly come to page number 28. This is the order, my lord, for issuance of PPO, my lord. Accordingly, page number 30, my lord, PPO was issued in the name of petition number 2, my lord. Thereafter, my lord, page number 31, one letter received, my lord, on to 2025, 21/3/25, saying, my lord, regarding the commencement of family pension, it is intimated that this office is unable to examine your case on the basis of above PPO number so and so, so and so, as mentioned by you. And the same is readily not available in this office. This was issued from Prayagraj, my lord, Uttar Pradesh. So now they are sitting over it, my lord. Nothing has been received, pension are not receiving, my lord.
What did you ask for?
We have already granted, my lord, the ordinary family pension, my lord.
Thanks to the AI, it has been given to ordinary family to Rimzi Mia, daughter out of the void marriage.
Yes, petition number 2.
So you are the second.
Second wife, petition,
No. Second
petition
wife.
number 2 is the,
Second wife has no business.
Yes.
Is she not major?
yes, sir.
Then why is the petitioner number 1 here?
They have communicated all the letters to her mother, that is why is.
Now to she has. Petitioner number 1 has no business.
See, herself is here.
Now what do you want?
My lord, now they, after issuing the PPO, my lord, they are not releasing the pension, my lord.
Earlier it was in the name of your mother.
First
No,
wife.
somebody else's mother.
That's why.
First wife.
And what is your age?
Now she will get proportionate, my lord.
What is your age?
Until, my lord, she is my, now, my lord,
Age was not there, Lord. In the affidavit, age is not there.
21 years, my lord. Page 2.
You are 21 years. Unmarried.
Yes,
Okay. PPO has been issued.
yes, ma'am. Page number 30 is the PPO, my lord.
30.
Yes.
So this, they are saying, they are not finding it.
Yes, my lord. But in their own department, my lord.
Then what did you do?
Not
My lord, repeatedly we are approaching the office here, my lord, but we can.
Verbally.
My lord,
Verbally. After that, what did you do?
my lord, after this letter, my lord, 21/3/25, I'm approaching this court, my lord.
Why?
Because they are.
Why haven't you approached
because
them?
already they have issued the PPO, my lord.
Understood. Therefore, you are requested to forward the scan copy of you. Have you done that?
No.
Yes, my lord. Lordship,
Then,
Where is
if
it?
may kindly, if some additional time, I will file additional affidavit.
No. Mr. S. Doctor appearing on behalf of the petitioner shall file an additional affidavit. Seeks for time to file additional affidavit as regards the course of action the petitioner number 2 have taken pursuant to
later.
the communication dated 21/3/2025.
Right.
Just 1 minute. What is your prayer? You check that today I have passed an order. In whose case I forgot? The one case, what is his name? I've asked them to, yeah. Oloskar. Oloskar, no? His case was there for the particular, look into that particular office memorandum. It's of relevance, 2022.
Right.
Huh? Which was it? You were there? Mr. Roy? No, she was there. List the matter, where, how much time? Okay, list the matter again on 16th of February.
I know.
Half an hour ago, my lord, I had a telephonic conversation with him half an hour ago. He said that he is still discharging his duties and the operator is pushing.
May I, my lord? My lord, will kindly come to page 12. Now, this has been with regard to his appointment in public service issued by Assam government. So far, Assam government is concerned, my lord, as per the 6th schedule area, paragraph 3B, it's a subject which has been entrusted to BTC, my lord. And it is always coterminous with regard to the government in power. It is always in coterminous with the government in power. And apart from that, my lord will kindly see the interim order with regard to status quo been given. Now that order, my lord, we have verified that he was not there. He was not discharging his duties after the, my lord, the cancellation of his all appointments and everything, my lord, by a executive council decision. He was not there. And so his status quo order was there, my lord. In the strength of status quo order, my lord, now they are attending offices. After the status quo order, my lord,
So why you are not obtaining instructions?
instruction has been there, my lord. I have obtained the instructions, my lord. It is there, my lord. We intend to file an affidavit for that purpose.
Okay, but first of all, what is your instruction?
Instruction is,
Instructions have been sought for as regards the interim prayer. His
Yes.
interim prayer is for stay of that communication.
yes. So
the
instruction has been
instruction?
received, my lord. And if your lordship allows me to file an affidavit, my lord, within this
We'll
week or
see later on. But as regards the interim prayer, there was already a notice issued.
Yes, my
What
lord.
is your instructions?
Instruction is this, my lord, that
So-
this has been an entrusted subject, my lord, wherein, my lord, with regard to
Now
the,
tell me then, in that regard, how can an office memorandum be issued in this manner? For all non-statutory, non-elected ad hoc organizations,
Yes, ma'am.
boards, so and so.
Yeah.
But isn't this a statutory board?
It is a statutory board.
So
my lord.
therefore, the office memorandum of 910 has no relevance with 1010.
Yes, my lord.
So
True.
therefore, if an action is being taken on the basis of the office memorandum, but the office memorandum only refers to non-statutory, non-elected ad hoc
Absolutely.
organization, boards and so.
Yes.
So therefore, the Kokrajhar Municipal Board,
It is a statutory body, my lord.
this is being a statutory body,
Absolutely.
this office memorandum would not have any impact.
Correct, my lord.
So therefore, this notification of 1010 has no force of law. So you do ahead, go ahead with 910. We have no, he also won't have any problem, but 1010 is wrong. And as desired by so and so, the Bodoland is pleased to dissolve all municipal boards and urban development authority under the BTC. This is a statutory boards. Municipal boards comes under the Assam Municipal Act.
Yes.
Urban development authorities comes under the Assam Town and Planning Corporation.
Absolutely.
So therefore, these being statutory boards, this particular document cannot be sustained in law.
So what I'm on, my lord, with regard to GMC laws and everything, my lord, it's been made out here, my lord. So far BTC adoption is concerned, my lord, it has been adopted with some modifications, my lord, with regard to this, my lord.
Which one?
If I is allowed to, my lord, please on affidavit, my lord, this facts.
But your very order, office
Yes,
memorandum
That's
which has
true, my
been
lord, that's
issued
true.
is contrary to the notification. So how can this notification survive?
That's true, my lord. It's contrary to the 9E and 10 is contrary to
We
it.
have this matter tomorrow. Get that instruction.
My lord, may I pray, my lord, on Tuesday, my lord, with folded hands, because tomorrow I'll be out of station, my lord. That's why, my lord. That's why, my lord. Monday
Then
I'll be back.
This notification cannot survive. Because this is contrary to the very office memorandum, the
Yes.
basis on which it is there, which state is.
Absolutely, absolutely right.
And if we state is, then he won't have any problem. You were working under the Kokrajhar municipal.
Kokrajhar Development Authority.
This is an authority under.
Maybe an authority, my lord, but my lord, will kindly see the page 12 of their writ petition, my lord. It's an order on the basis of which, my lord, they are holding office. Where is the power with regard to Assam government power?
No. For that, you take action on this is a different aspect.
Yes, my lord.
You have not cancelled this notification.
My
Or say that we are not bound by this, you are not saying.
Huh,
Whereas the office memorandum categorically says only non-statutory.
absolutely. That's
But as
absolutely-
regards, but you have applied that to municipal boards and urban development body, which is under the BTC, these are statutory.
statutory with modifications, but this order has been passed with regard to his appointment itself is by the Assam government, not by the BTC authorities, my lord.
You say that he has no right to be
Absolutely,
there.
absolutely.
That is another aspect,
Yes.
which you can very well take
Yes,
it up.
yes,
For him,
that's
which
what we
he
will
can
take.
very well come. But this notification is contrary to the office memorandum.
Yes.
So let office memorandum 910 remain.
Yes.
But 1010 cannot remain because it is only refers to non-statutory, non-elected ad hoc organizations.
My lord.
Or is it that so and so? The words non-statutory, non-elected ad hoc would not apply to boards.
These 1010, my lord, will kindly see. These are not elected bodies, my lord.
Which one?
These 1010 notifications, my lord.
No, come to 90.
9, my lord, yes. With
Whether
immediate
these,
effect,
that all non-statutory, non-elected ad
no,
hoc
under non-elected,
organizations-
it may come, my lord, because these are not elected chairperson or members. They
Understood.
are, yes,
Non-statutory,
yes.
oblique,
Non-statutory becomes different, my lord.
non-elected ad hoc organizations.
Organization boards, my lord.
Now, is
Municipality
boards taken out outside, specifically outside?
My lord, that can be an interpretation, my lord. That can be one of the interpretation, my lord. Non-elected boards, my lord.
No. If it is non-statutory, non-elected ad hoc,
Organizations.
is it only limited to organization or even boards also?
No?
If
Boards,
it is the boards also, then you have a problem with 1010.
boards and committees, municipal board, my lord.
The municipal boards cannot be said to be non-statutory. You cannot say the municipal boards also to be non-elected.
Yes. So one
You cannot
can-
also say the municipal boards to be ad hoc
My
or
lord-
town committees.
My lord, if I have correctly understood, they intend to say, my lord, that non-statutory is one category, non-elected, non-statutory boards is one category, non-elected or ad hoc organization is which consists of some board members or chairpersons is one this one, my lord, and committees are there with regard to this, with regard to non-statutory is another one.
So therefore, the municipal board which is there, or the Kokrajhar Development Authority,
Yes.
the Assam Town Planning Act duly applies to the BTC area.
Not wholly, my lord. They have, with regard to the appointment and all, they have different, my lord. Because this says with regard to
No, whether the act of Assam town planning
has been
applies.
adopted, my lord, partially, it appears, my lord, from the.
Show me
instructions.
where.
From
where
the
it is partially-
instructions, my lord, that has been provided, my lord. Yes. Wait. With this one?
And who is appearing for the government?
Second part of the instruction, my lord. There is a public notice, my lord, at the time, my lord, 2010. It has no approval also, his appointments, my lord.
No, that is another thing. For
Yes.
that you take up. You take up an action against that.
That I will clarify in my affidavit, my lord. In details, I will provide it.
Now kindly come to the first enclosure
Yes, my lord.
dated 17th of July 2023. In this connection, Boroland Territorial Council Kokrajhar has approved and directed to include so and so, ward number and so as chairman and member of the new body, Kokrajhar Development, and remaining members of the body will remain as per the body of the area. Isn't
Yes.
it therefore the approval given by the BTC?
No, this is a secretary with regard to the approval authority happens to be the BTC Executive Council, my lord.
It is being done. This is only being informed. In
Yes.
this connection, Boroland Territorial
Yes, it
Council
has been
has
informed, my
approved.
lord, in violation of the, my lord, the procedure they followed in here. Every executive council has to rectify that particular appointments.
All are understood, but this particular document otherwise shows so that it is already being granted.
My lord,
Boroland Territorial Council Kokrajhar has approved. It is not the secretary is intimating. It's a different thing, but this is a document of yours.
that's true, my lord, that's true.
Honorable BTC recommendation of the name of the member of the with reference to the Iman so and so. Submission of for nomination of this happened This regard is mentioned that the term of the existing board of Iman will complete in 5 years and shall expire on so and so. I would like to request you. This is given by the CHD Urban Development BTC. Deputy Director of Iman
11/7/23.
has informed that if the term of the above number will expire on demand, the above committee may be considered and so. For kind is forwarded for suggestion nomination of members. This so and so may be nominated a year. Who is the CEM?
CM, Chief Executive Member, my lord.
Member. So he is the equivalent to the present chief.
Yes, yes.
So he has said may be nominated. So this is given by the CEM. Now kindly see as approval of the Honorable CM, BTC and the order of the Secretary Urban so and so regarding to nominate so and so and so and so accordingly a draft letter is being prepared. So therefore, it appears it has been done.
Now, this is with regard to, my lord, yes, it appears to be this, my lord. I'll check it and my file an affidavit, my lord, with regard to this, my lord.
We stay this notification insofar as Kokrajhar Development Authority is concerned. heard Mr. P. Bhardwaj, the learned counsel, appearing on behalf of the petitioner. Mr. A. Bhuya, A.K. Bhuya, the standing counsel, senior standing counsel of the BTC, appears on behalf of the respondent number 2, 3, 4, and 5. Well, 4. 5 is who?
The operating, Kukrajhar Development, presented by the members.
But that has been dissolved.
Still functioning, man.
Okay. 4. State, no state.
State is not there, madam.
You are state.
One is the state.
Appears on behalf of the respondent number 1. Extra copies of the writ petition be served upon the respondents, learned counsels appearing on behalf of the respondents during the course of the day. As regards the respondent number 5, the petitioner is directed to take steps by way of speed post. In addition to that, by tomorrow. In addition to that, the petitioner is also directed to take steps by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. তার আগতে লিখিব so and so heard so and so আর তার আগতে issue notice খালি ইয়াৰ নামটো দি issue notice তাৰপিছত এওঁলোকৰ নামবোৰ দিব. The petitioner herein, who was appointed as the chairman of the Kokrajhar Development Authority for a period of 5 years under Section 8B, capital B, of the Assam Town and Country Planning Act 1959, read with Section 3 of the Rule 3 of the said rules, was appointed as the chairman of the Kokrajhar Development Authority, that is the respondent number 5, by the notification dated 5/8/2025. Copies of the said communication notification were forwarded even to the BTC authorities. It further appears that the petitioner thereupon joined as the chairman of the Kokrajhar Development Authority on 9/10/2025. An office memorandum was issued by the Principal Secretary, Boroland Territorial Council, wherein it is mentioned the contents of the office memorandum being relevant is reproduced hereunder. Page 14 or as desired of by order. A perusal of the above quoted, the relevant portion of the above quoted relevant portion of the office memorandum dated 9/10/2025 reveals that at the desire of the chief of the BTC of the Boroland Territorial Council, all non-statutory / non-elected / ad hoc organizations, boards, committees would cease to exist with immediate effect. And the concerned secretary of the said department was directed to issue separate notification with respect to the bodies as mentioned above immediately. On the basis of the said office memorandum, no, full stop. It is further seen that on 10/10/2025, a notification was issued by the Secretary, Boroland Territorial Council, on the basis of the office memorandum dated 9/10/2025, and dissolved all municipal board and urban development authority under the BTC with immediate effect. It further appears that the respective executive officer of the municipal board oblique the urban development authority was directed to look after the functioning of the municipal board oblique urban development authority until further orders. The question, this court, by an order dated 27/10/2025, had issued notice on the interim prayer and further directed the maintenance of status quo. Today, when the matter is being taken up, Mr. A.K. Bhuiyan, the learned standing counsel, senior standing counsel of the BTC, have placed before this court a set of instructions issued by the Secretary, Boroland Territorial Council, dated 29/10/11/2025. From a set of instructions which is been placed This is another instruction. You have given me two instructions. The said instructions are kept on record and marked with the letter X. From the said instructions, it appears. So said instructions and the enclosures thereto, it appears. That the Secretary of the Boroland Territorial Council, by the communication dated 17/7/2023, intimated the CHD, Urban Development Department, Boroland Territorial Council, Kokrajhar, that the Boroland Territorial Council, Kokrajhar, had approved and directed to include the petitioner and one Sri Nihar Ranjan Nath as the chairman and member of the new body of Kokrajhar Development Authority, and the remaining members of the body will remain the same as per existing body of the Kokrajhar Development Authority. It further appears from the office notes, which is also a part of the instructions, that the then chief executive member of the BTC had recommended nomination of the petitioner as the chairman. By the recommendation dated 7/7/2023. And it further appears that on the basis thereof, the notification dated 5/8/2025 was issued. Pusto. Be it as it may, a question arises as to whether the notification dated 10/10/2025. Now, as question arises as to whether the office memorandum dated 9/10/2025 as well as the 10/10/2025 can at all be sustained in law. More particularly, taking into account the application of both the Assam Municipal Act 1956 as well as, more particularly, taking into account the applicability of the Assam Municipal Act 1956 and the Assam Town Planning Act 1959.
Assam Town and Country Planning Act 1959.
To the BTC area. This aspect can be decided upon affidavit being filed by the respondent authorities. Be it as it may, this court also takes note of the contents of the office memorandum dated 9/10/2025. Without commenting on its legality or validity, it appears that the contents of the said office memorandum only refers to non-statutory / non-elected / ad hoc organizations, boards, committees. If that be so, under no circumstances it can be said that the municipal boards as well as the urban development authorities are non-statutory / non-elected / ad hoc organizations / boards, committees, taking into account the provisions of the Assam Municipal Act 1956 and the Assam Town and Country Planning Act 1959. Under such circumstances, it therefore appears to this court, it therefore prima facie appears before this court that the notification dated 10/10/2025 is contrary even to the office memorandum dated 9/10/2025. Which was the basis for issuance of the notification dated 10/10/2025. It is therefore the opinion of this court that the petitioner herein is entitled to certain interim directions. Accordingly, this court therefore states the notification dated 10/10/2025 insofar as the same is applied to the Kokrajhar Development Authority till the next date. Oh, issue notice making it. When can you file?
2 weeks, my lord, then, my lord.
Let's have it in the month of March,
I leave it to you, lord.
on 6th of March.
6th. Oblige, my oblige.
Motion? Motion diyo. Take it up. First motions will let us finish.
Rejected on the ground of overweight, Lordship.
Overweight.
Lordship.
His contention was that no measurement was taken.
What? No. matter.
My instruction, Lordship, I have got the videography, Lordship. It was measured, Lordship. By weight machine.
The rocket science to dismiss koribo. Dismissed.
Dismissed.
Overweight, nothing is there.
My lord, at present I am very fit, my lord. At present I am very fit.
You should have been fit on the date on which you were examined.
Obliged.
Dismissed.
Yeah, please, Your Lordship. It's a contempt petition.
এও এটা statement দি দিবা যে এইটো এটা মোৰ judgment আছে না rocket science এইটো দি আৰু এটা কৈ দিবা যে you have your instructions.
That it was measured, his contention was that no measurement was taken. Arbitrary, we have rejected.
Obtain instruction.
Yes, I have
Why
obtained,
haven't you obtained
I
instruction?
have obtained instruction by video. We have done the videography. We have the videography.
Where is it?
The in pen drive, Lordship, I have it.
Videography. Pen drive to undo.
It has measured by weight machine, Lordship. His videography was done.
এইটো videography to দেখাই দিব. That pen drive will make it a part of the records.
Lordship.
Dismiss কৰি দিম. Yes, Mr. Bora.
I think here, Lordship, the petitioner's candidature was rejected on account of height. And he filed a statutory appeal. That appeal was not decided. And thereafter, Lordship, he approached this honorable court. At page 9 and 10,
Appeal was not taken up.
no order has been passed, and that was not considered.
You have filed an appeal.
Lordship, on the same date, sir.
Then
Then, Lordship, we approached this honorable court, this honorable court directed to dispose of the appeal, if not disposed. And then, Lordship, we submitted the order on 39/2025. Till now, Lordship, nothing has been done. There's a direction to complete the exercise within 30 days.
এইটো envelope এটাত ভৰাই X কৰি দিব. Yes, Mr. In this case, give a copy to him. You are there, Ms. Gayan, in this matter, contempt. Where is Miss S. Borua?
She is in legs in court number 23.
Anyways, you see this order.
Lordship.
Page 9.
According to the petitioner, his height is 165.51 cm. However, in the physical test examination, his height was recorded as 164.
Lordship.
And he was therefore disqualified as minimum height required of male is 165.
Lordship.
Then the petitioner, this court passed an order taking into consideration submitted this court of the view that ends of justice if the petitioner is disposed of by directing the respondents, more particularly the respondent number 7, to expeditiously consider the appeal stated to have been filed by the petitioner and pass appropriate direction. If in the meantime the appeal has already been considered and order has been passed, then a copy of the same be served, that will be completed within 30 days. Here, normally issuance of notice in a matter of days will have a delay the matter.
Lordship.
So therefore, as I normally do, I will ask you to obtain the instructions as to whether any, he has filed an appeal.
Lordship.
So
Whether-
whether you were measured,
No, in the appeal, that remeasurement was not done.
so you have not been measured.
No.
So as to what action has been taken.
Lordship.
The instant application has been filed alleging willful and deliberate violation to the order dated 24/9/2025 in WPC number 5684/2025. Full stop. A perusal of the said order dated 24/9/2025 reveals that the petitioner's height, though as per him is 165.51 cm, but in the physical test examination, he was recorded as 164 and the minimum height required was 165. The petitioner wanted to file an appeal. However, the same was not permitted And as such, the petitioner had approached this court by filing the writ petition being WPC number.
If he filed the statutory appeal, but the appeal was not considered.
The petitioner thereupon filed an appeal, but the said appeal was not considered. And under such circumstances, the petitioner approached this court by filing a writ petition being WPC number 5684/2025. The order which has been passed by the learned coordinate bench, the order dated the directions which were issued by the learned coordinate bench in the order dated 24/9/2025 reads as under paragraph 6 to Bhoyaliba. At paragraph number 6 reads as under. The petitioner thereupon, on 30/9/2025, within the period of 7 days as permitted, submitted an appeal along with the order passed by this court. It is the allegation of the petitioner that the same have not been considered, and as such, the present application. This court have requested Mr. S.S. Roy, the learned standing counsel, the learned CGC, CGC, to obtain instruction as to whether the order dated 24/9/2025 passed in WPC number so and so have been complied with. And further as to whether complied with. And as to whether the petitioner's appeal have been taken into consideration. A copy of the contempt application be provided to Mr. S.S. Roy, the learned CGC, during the course of the day.
Already.
Full stop. The name of Mr. S.S. Roy, the learned CGC, shall also be reflected in the cause list. List the matter again on how much time?
1 week, Lordship, with
Okay. List the matter again on 13th, possible? Only that instruction.
13,
1-3
Lordship.
on 13th of February 2026 for motion. And an update by Mr. S.S. Roy, learned CGC.
Page 52, advertised my lord, that is 16, where I can participate in the election. And for that purpose, data has also been retained by the concerned MSCP Golf Park to the Registrar General Guwahati High Court.
So why you are not allowing him to participate? He has worked with you for all these years. Why didn't you permit him? Relax this 11 years and allow him to permit, taking into account all these things. Making no sense. On one hand, you don't regularize him. On the other hand, if you don't permit him, makes no sense. Let him permit as per this. Don't you think so?
Let it be on Monday, my lord, I will take instruction.
Let it be on Thursday. I'll issue short notice on Thursday as to whether you will permit him. Take a decision on that. Because he has been working all along.
Right.
There's no quarrel with that.
No, right.
Now, the fact that if it is on an advertisement, he applies and gets it, it is well and fine. Then he is regular. But you know, this going into all this regularization business is not there.
Will not come.
It will be done as
Yes.
per the advertisement.
If it is permissible as per provisions of law, then lordship may dispose of in that line also.
No, let me wait.
Other period lordship has already. No, if he is permitted to participate in the recruitment lordship.
No. There is a prayer made by him for relaxation. You
Yes.
see, the petitioner has been working from 2015, na? 2015 he has been working. Now, on one hand, he's claiming for regularization. Whether he gets or not, that's another thing. But on the other hand, there is a process of advertisement going on for filling up that post. So let him participate in that.
Yes, that is what
I
I'm
think that
submitting.
should be the
It
most
is
reasonable.
permissible, Lordship, for relaxation of his upper age, Lordship. Let him participate.
But
That is
other
the only.
dual pair are there, regulation is also the pair let.
Why regularization? Once you participate, there is no regularization.
In case of my, this is the first.
Huh? Because that post will be filled up.
Absolutely
You
correct.
cannot then.
Let it be kept pending. whether there is
No, I'm
any-
keeping it pending. I'm having it on Thursday as to whether his case can be regularized, taking into account that the petitioner have all these years.
Yes.
Let him opt in. Once that is given, this is the post. Thereby he cannot. He has also asked for a relaxation.
No, Lordship, just I am asking one question. Bholanath case, my lord, how far it is, my lord, in my view, my lord.
You don't have a right for regularization. I make it well.
No, that Bholanath case.
Till I am very much against this regularization business. You have not been appointed as per a regular process.
Yes.
You have just been appointed by some member one fine morning. You go without a selection process. This is the concern of regularization is foreign.
But Bholanath case about the selection process was conducted. In Bholanath case, selection procedure was conducted.
Where?
In Bholanath case, recent case.
Bholanath, all these things are selection process. Bholanath and all other cases.
Yes.
Election or no selection, you cannot. This is
Yes.
regularization on this type of appointment cannot be given. Issue notice making it returnable on 13th of February 2026 at 2 p.m. Mr. You accept notice for Judicial Department? No.
No, only for everything.
Ms. So-and-so accepts notice on behalf of the respondent number 1. Mr. G. Busho accepts notice on behalf of the respondent number 2, 4, and 5. And Mr. P. Nayak accepts notice on behalf of the respondent number 3. Extra copies of the writ petition be furnished to the respective councils during the course of the day. The petitioner was appointed on contingency basis as a casual employee on contingency basis in the office of the member MACT Gwalpara. At a fixed pay. By an order dated 2/5/2015. Thereupon, the petitioner had been continued from time to time. And as on date, the petitioner still continues to render service as a fixed pay employee in the office of the MACT Gwalpara. The petitioner has prayed for regularization of his services, taking into account that the petitioner have already rendered more than 10 years of service. Be that as it may, it appears from the materials on record that the office of the member Motor Accidents Claims Tribunal have issued an advertisement on 16/1/2026 for filling up of one post of MTS bracket Group D Roman 2, wherein the petitioner can apply. One of the preconditions for the said post, for applying to the said post, is that the candidates must not be less than 18 years of age or more than 40 years of age as on 1/1/2026. Apart from that, there is age relaxation as per the government norms for OBC oblique SC oblique ST candidates. You belong? To which, however, admittedly, the petitioner do not belong. Be that as it may, the petitioner, on the basis of his service so rendered for the last 10 years, submitted a representation before the learned member MACT Gwalpara seeking age relaxation. However, the same have not yet been considered. And it is under such circumstances the petitioner has approached this court. It is relevant to take note of that the last date for submission of the application is 16/2/2026. Considering the above, this court therefore directs the respondent number 2 as well as 5, to respondent number 2, for whom Mr. G. Bosher, the Learned Standing Counsel of the GAC, appears to obtain instruction as to whether the petitioners can be granted the age relaxation, taking into account that the petitioner has rendered 10 years of service, admittedly, in the office of the Motor Accidents Claim Tribunal. Gwalpara. List account. Mr. Bosher, I think the High Court should permit it taking there. Then only things become normal. No? Otherwise, this court will have a lot of
Only
problems.
thing is he is 53. He is now 53.
Maybe, but the
But
problem will be this.
Final.
If he cannot be taken, he will be a fresh appointee. He will be there. The question is the question of all this pension and all, the question doesn't arise.
Fine.
As per the NPS, if he is entitled to
Fine.
it's different aspect, he has to deposit amount, this amount will be given, this is how it
Fine.
works.
Fine.
Chalo.
Obliged, man.
Mr. Bora, why I said about this is because of a judgment of the Supreme Court. While in fact, after that, normally I look into whenever I pass an interim order or a final judgment as to whether I'm correct. And it immediately came up. What is that judgment name? Huh?
Sakshiara.
And that was very damaging for you. Not only that, then I searched further. Then I got a Bombay High Court judgment, division bench, against you. The problem which has happened is this. In fact, the Kerala High Court, I think, had made a mistake on one, although Kerala High Court's judgment is on another point. They put a date 180 days after the filing of the application. So therefore, the question was whether it was proper or not. They applied the judgment of the Supreme Court in the case of Ram Gigoria or something, where the question is also different, a bit different from what has happened here. Here, if you see, from 1993 onwards, there has been office memorandum notifications specifically saying that it has to be the date on which the application is to be submitted, because you have to be eligible then. Now, in this judgment, see how much of things I've got. Sakshiara. In Saxiara, which is again a three judges bench now, the specific question was that in the advertisement, although it was not there, but in a subsequent advertisement, the date was inserted as the date on which the OBC and NCL certificate which has to be there. There, the Supreme Court says a very interesting aspect, which seems to be contrary to what has been held by the division bench of the Kerala High Court. Do you have a judgment copy of this? Can you see paragraph 17? You have seen?
Yes.
Paragraph 17. Undoubtedly, while the status of a candidate belonging to the scheduled caste or scheduled tribe is determined by virtue of one's birth, however, as opposed to the unbating virtue of being an SC or ST candidate, the status of a candidate claiming to be OBC, NCL or MBC, NCL or EW is constantly subject to transposition owing to their social or economic status with the concerned jurisdiction. It is on the strength of this reasoning that the decision in so-and-so further categorized the backward class into creamy and non-creamy layers as an attempt to differentiate the affluent strata so as to allow for the reservation for those who are truly warranting of the affirmative action. Now, if you see the Kerala High Court judgment, the division bench judgment, more particularly paragraph number 10, it says otherwise. Now, here what has happened is the Rajasthan High Court dismissed the writ petition, dismissed, and the matter went to the Supreme Court, and kindly come to paragraph number 27. No, not 27. Yes, paragraph number 32 onwards. 31. 22. Paragraph 31. Prima facie, the arguments rendered on behalf of the appellants appear before us appears to be judicious if limited scope is the advertisement, but clearly the advertisement does not exist in vacuum, nascent of the world, outside world and the laws of the land. The decision of this court and the guidelines on the category certificates thereof would invariably impact the scope of interpretation and execution. Then paragraph 30, the relevant laws, rules, instructions and reproduced and referred earlier clearly indicate that a certificate of claim as put forth by the appellant herein is valid for a period of 1 year from the date of issuance and subsequently extendable up to the 3 years, provided an affidavit to the said effect is also produced along with the originally issued certificate. Moreover, the decision of this court have clearly cleared the air of any doubt that the claim made by the candidate while filing his or her application as per the concerned advertisement are to hold good as on the date of his or her application or as on per the last date of submission of the application prescribed by the concerned advertisement. It is true that the advertisement in itself did not really mention the date with regard to the issuance of a category certificate and that it came from subsequent notice which was asserted. So cannot be said to be arbitrary or without any basis. It is specified that the certificate belonging to the concerned reserve category should be issued prior to or up to 31/8/2021, that is the last date of receipt of the application in pursuance to the advertisement. This was because the advertisement required the candidate to possess eligibility up to the cutoff date. As regards the specification regarding a certificate issued between so-and-so and so-and-so, along with the affidavit is concerned, this was based on the government circular dated so-and-so 9/9/2015. I think this is what you are bringing.
Yes. Yes, now by
Today-
additional
Here
evidence.
the notification date is different.
No.
Additional affidavit.
Okay. You are bringing.
This was
what-
the Rajasthan government circular.
This is 8 October of 2003.
Okay, 8 of reiteration of the instruction on verification of the claims of so and so. Yeah, here you refer to, see, in Annexure G, 9/9/2025, 2005, isn't it?
9/9,
Yes.
2015.
15 or 5.
Also has a reference to the notification.
This was the
So
Rajasthan State.
reiterated in issue where candidate belonging to the scheduled caste is unable to produce the certificate from any prescribed, he or may be appointed provisionally on the basis of so and so and is able to produce in support of her caste subject to his or furnishing the prescribed certificate within a reasonable time, and if there is a genuine difficulty, his or her. Office memorandum of Surya, the department has received various references via every candidate seeking reservation in central government and so is required to submit a survey confirming his or status of and also produce a non-email. Would be applicable to OBC candidates who were covered under the income. The income limit is decided on the basis of income earned during the 3 previous financial years preceding the year of appointment. Illustrated terms. On this issue, the National Commission has suggested a new format for name. It is requested that the comments on the suggestion made in para number 1 of the Iman to streamline this so and so. This one does not say anything, but anyways.
Paragraph 21, the circular has been
Huh?
discussed. 2025 SSC online. Sakshiyara. Paragraph 21, the circular was there.
1.1.
The circular dated paragraph 999, 2015.
Para 21.
The certificate validity of
Circular of 99 notified that a certificate of NCL shall be only issued for so and so will allow the Iman. In reference, the position was subsequently clarified and crystallized by the state of Rajasthan in so and so. However, the maximum period to allow the practice is to continue is 3 years. To allow for this practice to continue is 3 years. 3 years. This one. Anyways, now kindly see here. Reproduced above, which clarified that the certificate issued will be valid for 1 year, extendable by 3 years with affidavit. Thus, the subsequent notice issued was in consonance with the law and as per the advertisement, applicable rules and so by the year. The plea of the appellant is unsustainable and deserves to be rejected. No relaxation can be granted in a given facts and circumstances of the case, nor can it be claimed as a matter of right in absence of any discretionary clause in the advertisement, rules or instructions. Now kindly come to the next paragraph, paragraph 38. Significant reliance is placed by the appellant on the 2 judges bench decision of this court in so and so. A perusal of the decision rendered by the High Court of Delhi on the factual matrix therein is evidently distinct. The same thus cannot come to the rescue of the appellants in the instant case. It is not a contention of the appellant that they are missing a valid proof of attainment or their particular qualification or right. No candidate before us has a claim that they to begin with already availed and established their eligibility or had applied for an NCL certificate, category certificate, and issuance of the same is delayed at the behest of the competent authority. The ratio, therefore, in the right judgment would not apply. Now, how do I help you?
For a moment, your lordship may kindly see on the paragraph above 38. Their lordship, none of the candidates were having the OBC certificate within the financial year firstly, and nor the affidavit.
No. Financial year is not the question here.
Lordship, that was in fact not decided, not discussed.
Here the issue is as on 31/8/2021, you should have the certificate.
Their candidature was rejected.
Now there is a reason why. Just for example, these certificates are valid for only 1 year.
1 year.
And if you have a certificate later on and on the date on which you submitted your application, you were not
NCL.
qualified without that certificate. So therefore, clause 6.5 on the face of it cannot be said to be bad. Problem lies there. As I said in the earlier, without a challenge to clause 6.5, you cannot sustain. And can you say to be that the clause 6.5 is bad?
In 2017, that clause 6.5 is bad.
17.8?
That is at my petition page number 97. Because the first paragraph of that particular notification specifically.
17.8 page?
97. 17.
No, this is different again.
This is OBC.
This is only for that case. Kindly see the Kerala High Court judgment. You have the Kerala High Court judgment?
No.
Okay, that day you gave it to me. Kindly see here. See paragraph 6. Paragraph 5. The Learned Standing Council, Central Government Standing Council contend that as per the process of certification and the format of certificate under clause C of the notification, the OBC certificate has to be dated within 180 days from the last date of the application. That is on or before so and so, clause C. It is contended by the petitioner respondents in their counter affidavit that clause is applicable to all the candidates who wants to claim OBC certificate benefits, and the validity of OBC certificate is 180 days from the closing date of the application. It is also submitted that the reason for such prescription is to ensure that only persons who are entitled to apply under the notification would have been permitted relaxation under the notification. And since the state may, even after notification, include communities under the OBC category, it is to ensure that such a, so this is the submission. Now what happened out here? Kindly see the findings. The declaration, paragraph 10, the declaration at exhibit 10 has been signed by the petitioner. The petitioner declares that the petitioner mentioned in the said document has been checked by him and found today. It is also declared that he understands the particular. Despite the restriction in the notification, the petitioner having declared as having verified the preference and so and so. Despite so and so having found rejection is bad, it is only proper that the respondents consider that petitioner for the year. It is submitted by year for that for want of sufficient successful the candidate have conducted in India, divorce the year. Now here if you see, yes. Herein it is to be noticed, para 7. The petitioner is a Muslim whose community has also all along been in the OBC. Even at the time of issuance of the notification, the petitioner was already a member belonging to the OBC, as is evident from EIR issued on so and so prior to the notification. A reading of does not indicate that it is a restriction, especially read along in so and so. Therein, it is specifically provided that the requisite certificate for availing reservation or seeking age relaxation from the competent authority in the prescribed format has to be produced at the time of interview or a documentary revision. The OBC candidate have been permitted to produce OBC issued within 180 days from the closing date from the for receiver. This court cannot find the same to be a restriction and can only be an enabling clause which enables the respondent authorities to consider the inclusion of any community under the OBC category within 180 days from the last date of application. Now, if you see the division bench judgment, which I think
The guideline was framed by in 1993 supplementary 3, Rekha Chaturvedi's scheme.
Rekha Chaturvedi also categorically says on the date on which you
Yes.
apply, you have to be here. Now,
The guidelines was set.
in this regard, if you see certain other things, just for example, (27/5/2013). It all starts with that 1993 document. In railways also, there is also another year. The appointing authority before appointing a person seeking an year so and so, the crucial date for this purpose may be treated as the closing date for receipt of the application for a post. Then in 2003 also there is an office memorandum. This is how it is being done. 2008 revision of income. So therefore, the problem lies there. First DOPT instruction is 1511. In fact, the entire history has been culled down in this Bombay High Court judgment, division bench judgment, wherein it has given details of all the circulars right from the beginning, format, everything. It all started with that office memorandum, DOPT thing in 15/11/1993.
93.
So therefore, all along, it has been held that these, here also, they put it on a particular date. There was a specific submission made, which was also being made at one point of time by another council. He had made one council, that my OBC status does not change. I continue to remain. But this is being answered in Sakshi Araha,
Yes.
wherein in that paragraph number 17, as I showed you,
Lordship.
it is always it is very dynamic. It will change every year. It may change every year
Every.
because there is more particularly there is some changes also in the slabs also.
Yes.
4.5 lakhs to 6 lakhs and all
6
these
lakhs.
things are there. So
That is where the income within the financial year has to be taken into consideration. And the notification also which I have annexed, it says that it will cover the case, it does not cover the cases. It does not say that it will cover, it will not cover the cases after 2017. Because the first paragraph of the notification clearly states that commission had already issued notifications earlier also, putting an outer limit of 180 days. So therefore, Lordship, what we are saying that the certificate which was issued within that 180 days limit, after the cutoff date, that has to be accepted.
no, that is because of 4C. It is there in 4C. Why I said 180 days? Because of the 4C, which is there in the Kerala High Court judgment. If you see 4C, that particular clause is there in 4C.
6.1.
No. 6.1 doesn't say so. Here you see 6.1 says candidates who wish to be considered against reserved vacancies or so and so are required to submit the requisite certificates from the competent authority in the prescribed format. When such certificates are sought by so and so from the document at the time of verification. Otherwise, their claim for SC/ST candidates will not be entertained and their candidature application will be considered under so and so. Just for example, now they are having around how many people you are going to recruit?
More than what? 55,000 odd. Almost 55,000 odd.
Now 55,000.
59.
Okay, all over India, in Assam, there will be somebody. Now, just for example, if we take clause 6.1 as the date on which the application is to be issued, the non-creamy layer is to be given. Your interview is taken in the month of March. His interview is taken in the month of April. If you don't have a cutoff date there, you may not be able to get on the month of March. And in the meantime, he has got it in the month of April. Whether there won't be a violation of Article 14, that is what has been held by Rekha Chakraborty.
There are 10.
Problem arises there. Therefore, you need to have that. And therefore, in the Rajasthan High Court matter, what they did, if you have a certificate of 1 year, you are need to file an affidavit
That I have.
along with the original certificate. And this aspect is further clarified out there in the Bombay High Court judgment, where it is given details as to how the affidavit is to be filed and why the affidavit is to be filed, that in the meantime, in the next occasion, just for example, 55,000, the process may not be complete. You are selected on 14 is the last date. 14/10/2024 is the last date. Thereupon, the matter goes to in the month you are being interviewed in the last part of December. Okay. First person. Those persons concerned who had it on 14/10 would not be having it on 14, would not, that validity has gone. So therefore, they have to file an affidavit. So therefore, they will see two things. One, first, he has a certificate. And second, that affidavit also should say that if you are no longer a criminal, you lose your thing. That's the mandate of law.
All the applicants were not having that particular certificate within the financial year and they did not file the.
Yes, that is also. No, and they had it subsequently.
They should not find, because in the table which is there, above paragraph number 38, there your lordship will find the cutoff date was 31/8/2021. All the certificates were issued this year 2022.
Yes. So by the time which was there,
The financial year was also
over, but whatever may be,
In
you
the-
kindly see
The
this.
observation also your lordship will find.
Now kindly see 31/8/2021. See the number one Sakshi Arha's case at page 30, paragraph 37.
12/8/2022.
First is 27/7/2016,
Yes, that is the main officer, sir.
the first one.
Yes.
So as on 31/8/2021, he didn't have. Okay, but he had it on 17/6.
That is after the financial, end of the financial year.
Maybe, but on that 17/6 he had.
No, that also after the financial year, because the financial year ends on 31/3/2022. And the categorical observation of the apex court is that lordship, the above details should make it clear that the none of the applicants had a valid certificate.
Valid certificate and or
And it
accompanied by an
accompanied
affidavit
by-
as
so
per
they
the
did not even
performer
find
at the
any
relevant
certificate.
time, as per the requirement referred to above.
Lordship.
As per the requirement referred to above.
When the Rajasthan government is that they have to file an affidavit. Considering the income of the three preceding years.
No. Their last date of submission is 31/8/21.
So as on 31/8/2021, they had to have it.
You have
That
all the
paragraph 21
qualifications.
one takes care of that. Because it says the validity period of caste certificate, the poem number stated 9/9/2015 was referred. Validity of the caste certificate issued for SC, ST, OBC.
No, if we say the financial year, just for example, but how can you have it for the financial year?
Next
You
financial.
see, just for example, let us give you an example. If we consider it to be the financial year of 1st of April to 31st of March, is the financial year? You obtained here the certificate on 7/1/2026, 25. Your last date is on 14/10/2025, 24. Now, this certificate is valid for 1 year. So, doesn't it crisscrosses with the financial year then? My question is therefore there.
If I get a certificate prior to.
No. Just for example, you have a certificate on 14/10/2024, which is one of the petitions here. You'll find out after some time. 14/10/2024 is your certificate, which is the last date. Thereupon, it is valid for 1 year. Meaning there, it intrudes into the next financial year. How is it possible then? If we accept your argument. Why not? It is valid for 1 year.
But only for that particular financial. Even if it is issued on 14/10/2024, it will over only 31st of March.
How can it be for that financial year because of the fact that it has to be based upon the findings on the previous financial year?
Yes.
How do you give this 4 lakhs or 6 lakhs? On the basis of certain document?
Yes.
So this document has to be based upon certain things, your annual statement, your income statement and all, every financial year. So the 14/10/2024 document has to be on the basis of that period,
Three preceding years.
ending 31st of March 2024. But this certificate is made valid for 1 year from there. The reason for making it valid for 1 year for that is that because this time will be taken for the purpose of recruitment. That is why they normally take it.
Logic.
And therefore, the question of filing an affidavit is being given so that this period can be extended. I think division bench will be better.
But the difficulty is with respect to the notification dated 17/8/2017. Because there is no subsequent notification issued by the respondent that this certificate.
No, problem is with the judgment of Sakshi Arha.
Okay.
it has, if this judgment was not there, things would have been different.
To be my respectful what submission and what I understood. In Saxiara, they failed because they could not produce the certificate within that validity period.
No, it says that it on 31/8/2021 they
You
could not
don't,
do it,
you don't have any.
which was the last thing. That makes the problem everywhere. I think the division bench should be more considerate. I should not delay the matter any further. Anyways, I'll dismiss
In
it.
fact, for a moment, if I take your lordship to page 42 of my petition,
Ah,
sorry, 29 of my petition,
ah,
if the clause 6.8 is provided.
ah.
If your lordship can
May also note that in respect of the above, their candidates will remain till the veracity of the document concerned is verified by the
6.5?
appointee. May are concerned that they will be debarred from examination conducted by AI in case they are fraudulently given. No, that is another
No,
aspect.
why I am saying that, lordship, clause 6.5 is why arbitrary, because the notifications of 2015 specifically mandates that if I produce a prima facie proof of being an OBC, then they have to consider my.
No, that is the problem with the judgment again in Saxiara. It takes care of that situation at paragraph 17.
And therefore, clause 6.8 is also incorporated in the advertisement.
Clause 6.8 is different. Just for example, you say that you are an OBC and give a fake certificate. And thereupon it was on verification, it is found that even if you have passed the written examination, everything, and on verification, it is found that this is false. Matter ends. I think we'll dismiss your petition. I'll pass the order in a more detailed manner so that it becomes better for you for filing an appeal. But I think we need, I'm closing it because you see, issuance of a notice and not granting you a stay would make your petition infructuous, Mr. Bora. You see, I also understand.
May I pray that your lordship may give me some more time on this aspect? I will try to find out if I can find anything. On Tuesday, your lordship may fix it on Wednesday. I will just, because this judgment of Supreme Court has.
I asked him to give it to you.
I've given on the
Yes,
same day.
And thereafter, lordship, I-
You see, the moment that day after passing that order, it was lying in the, so then I was just going through it and just found this judgment immediately from somewhere. You see, I think these must be these mobile phones has there, they hear.
Yes.
So you must be getting whatever you keep on talking, you get it out there in the Google out there, whatever comes in.
Yes.
So it automatically came out. And that too in case mine.
Yes,
Making a reference in case mine. And thereupon, then I searched and took out the judgment. I said, oh, this goes against it. So I asked him, I didn't have your number. So I asked my person to give him a call and say that, tell him this is the state of affairs. I can't, I'll have it for again on Friday so that in the meantime, he can go through the judgment. Because opening, the moment I give you a stay here, it will be opening
Floodgate.
floodgates.
One of.
And if I don't give you a stay here, your petition becomes infructuous.
Because they will fill up the post by then. Lordship may fix it on Wednesday.
Anyways, do one thing. Anyways, I've spent a lot of time. Let it come up on Wednesday.
Lodge.
I'm not here on Wednesday, so let it be done by Wednesday. Okay. Mr. Arbora, appearing on behalf of the petitioner, submits that taking into account the judgment in the case of Saksi Arha versus Rajasthan High Court and others, reported in 2025 SCC Online SC 757, he would like to further and the judgment of the division bench of the Bombay High Court in the case of Rachna Deepak Pedkar versus State of Goa 2025 BHC Goa 1713 DV. He would like to a further opportunity to address this court on these judgments. To list this matter again for further consideration on, let's have it on 13th. 13th?
As a part head lodge.
Part third, I don't like to make, Partha, it will come. If it comes before me, it's good. Otherwise, it will come up before. But anyways, but this is the state of affairs. Anyways.
Video by the segment.
ASI in the DSF and its promoter should have looked at ASI has been not rejected on the basis of an material adverse remark of the APAR of 2020. What is may what you mentioned the APAR, the observation. It starts from page 32 and the relevant in the observation is at page 36. Okay. In violation of the guidelines, this has been recorded and moreover that this has not been communicated to the petitioner also.
Your entire case is based upon that it is an uncommunicated adverse remark.
Yes, one of the ground is uncommunicated and another is before giving any adverse remark, he has to give counsel or giving warning thereafter they can give and as per the guideline. So in both, this has not been covered.
Okay, we'll issue notice, short notice, and then find out as to whether this has happened or not. And if happened, then we will fix it for passing of interim directions on the next date. Issue notice making it returnable on 2nd of March 2026. Ms. So-and-so accepts notice on behalf of all the respondents. Extra copies of the writ petition be provided to the Ms. Gayan during the course of the day. The grievance of the petitioner herein is that the respondent authorities have taken into consideration certain adverse remarks recorded by the initiating/reporting officer relating to the petitioner's communication/behavior with the colleagues without communicating to the petitioner and also without informing the petitioner about the adverse remarks. Full stop. It is the case of the petitioner that in view of that adverse remarks taken uncommunicated adverse remarks, the petitioner have also not been considered for promotion. Full stop. It is under such circumstances the petitioner has approached this court seeking seeking appropriate directions for setting aside the adverse/advisory remarks of the reporting officer in the petitioner's APAR for the period from 1/4/2022 to 31/3/2023, the order dated 27/9/2024 of the Commandant, 126 Battalion BSF in rejection of the petitioner's representation and other consequential reliefs. The petitioner have also sought for consideration of the case of the petitioner for promotion to the post of sub-inspector without taking into consideration the impugned adverse/adverse advisory remarks recorded in the petitioner's APAR for the year 2022-23. The respondents herein are directed to bring on record their stand by filing their affidavits on or before 24/2/2026. As regards the stand, in respect to the case set out by the petitioner. Apart from that, the respondent shall also indicate in the affidavit as to whether the adverse oblique advisory remarks against the petitioner were for the year 2022-23 were at all communicated to the petitioner. And further, prior to making the adverse oblique advisory remarks, any counseling was conducted. This court further observes that Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that certain interim directions may be passed. It is the opinion of this court that without obtaining the said instructions as sought for, it would not be proper on the part of, it would not be in the interest of justice to pass any interim directions at this stage. It is the same shall be considered on the next date. It is further observed that in the circumstance it is observed that in the circumstance, no affidavit has been filed providing the instructions as sought for. This court may consider passing appropriate interim directions. Yes. Huh?
Non-creamy layer certificate.
Creamy layer.
Non-creamy layer. Lordship, I would like to take the Lordship attention to clause 12.
Yes, you have that. This is what I was saying to Mr. Bora.
Yes.
Your certificate is on the date of as per 14/10/2024. But Mr. Counsel, only thing we need to inquire is as to whether you produced it at the time of verification.
Category statement.
No, that is the only basis. Nothing further remains. Although the petition is bulky, but the short question available is that only. You have a certificate as per 6.5.
Yes. 6.5.
You have a certificate, but the fact remains as to whether at the time of verification conducted on as per clause 6.1, you produce this certificate or not.
Certificate at page annexure C.
Issue notice making it returnable on how much time, madam? 27th February?
Last of February, Lordship.
That is why I'm saying 27.
Yes.
There cannot be any further date because that is the last date. Issue notice making it returnable on 27th of February 2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1 to 7. Ms. So-and-so appears on behalf of the respondent number 8. Extra copies of the writ petition be furnished during the course of the day. The petitioner applied to the post of Constable GD in the Central Armed Police Force pursuant to the notice dated 5/9/2024. In terms with clause, the petitioner, clause 5 of the said notice dated 5/9/2024 stipulates the age limit. In the case of an OBC candidate, the age is relaxable by 3 years. For unreserved category, the age as on 1/1/2025 should be between 18-23 years. The petitioner applied as an OBC candidate and had also the OBC non-creamy layer certificate dated 14/10/2024 issued by the respondent number 8. which is in terms with clause 6.5 of the notice dated 5/9/2024. However, it is the case of the petitioner that the respondent authorities, without considering the same, rejected the said application by the order dated, by the rejection slip dated 4/12/2025. The question therefore arises in the present facts and circumstances that as to whether at the time of verification being carried out in terms with clause 6.1 of the notice dated 5/9/2024, the petitioner produced the said certificate dated 14/10/2024. Apart from that, this court have also taken note of the fact that though the petitioner has a certificate on 14/10/2024 issued by the respondent number 8, another certificate have been enclosed, which is annexes E, that is 25/4/2025. The respondents is also required to apprise this court as to whether the certificate dated 14/10/2024 is as per the notice dated 5/9/2024. Under such circumstances, taking into account the above, the respondents are directed to file an affidavit on or before 24th of February 2026, providing the necessary instructions as has been sought for. It is also the opinion of this court that the petitioner, on the basis of Annexure C, that is Annexure C to the writ petition, that is the non-criminal certificate issued on 14/10/2024, has been able to make out the case for interim directions. Accordingly, till the next date, the respondent authorities shall keep one post one post of Constable GD in the Central Armed Police Force vacant. What has happened to the tender?
My lord, not given, LOA has not been given.
Here is the case where the petitioner could not submit the security, the earnest money.
My lord.
May my lord start with your lordship's permission?
Yes.
Your lordship, my lord, this is the same case as your lordship have pointed out. The entire question was about the submission of the earnest money by the petitioner. But before I take your lordship to the aforesaid submissions, I will draw your lordship attention to Annexure 6, page 56, is a NIT.
Page?
Page 56.
Yes.
Your Lordship may kindly see, this is NIP, where the last date for the submission of the bid is 16 July, and it is for design and construction of a steel bridge. Your Lordship can have a look at, my lord, at page 67, clause 11.
Yes,
Your Lordship may have a look at the clause 11.
yes, I've looked.
Two
into it.
types of bidders are, my lord, exempted from the submission of the bid security. EMD, earnest money deposit. Number one, those who were enlisted with the BRO. Number two, who were MSME small. Registered firms, they were all exempted from the submission of the bid security or EMD. EMD. Now, your Lordship may kindly, this is clarified by in the terms and conditions of the documents. Your Lordship may I kindly have a look at, my lord, page 72, clause 11.
Clause,
Clause 11, page
I've
72.
looked into.
Your Lordship may kindly see, my lord, insofar as the unlisted contractors are concerned, and insofar as enlisted contractors who have not deposited the security, my lord, deposit, they were required to submit the bid security, EMD, earnest money deposit, to the tune of rupees 15 lakhs.
Yes,
My bid is held to be non-responsive in the first round. Your Lordship may kindly have a look at Annexure 9.
annexure,
Annexure 9,
page,
page, sir,
197.
197.
Yes,
Your Lordship can see on what ground my bid has been held to be non-responsive. At page, my lord, 200, serial number 6.
yes,
EMD, the reason which is cited by them to reject my bid, technical bid, is very clearly mentioned by them that I am an enlisted contractor. I have given the security deposit to the tune of 11 lakhs. They say, although you are enlisted contractor, but your limit is 11 lakhs security deposit. So you have not given the balance 4 lakhs. This was what they had stated. Yes, my lord.
Okay.
I submit a representation to them. Your lordship may
No,
have a look at it.
Mr. Pant, the matter has come up before this court, although I'm not holding the roster taking into account the order which I have passed on the date when the matter was moved.
Yes,
Let me tell you what is the case about.
yes, ma'am.
Clause 11 permits
Yes.
that a person who is an enlisted contractor and an MSME need not submit the earnest money. Initially, on 31/7/2025, they took a plea. Then look here, the earnest money required is 15 lakhs. You being an enlisted contractor have only submitted 11 lakhs. So there is a deficient of 4 lakhs and as such you cannot get the benefit.
Yes.
Thereupon you submitted various documents and thereupon they took another ground now on 7/11/2025 that look here, for the purpose of getting the benefit, you have to upload it in the document. And having not uploaded that particular document, it has been shown as medium.
Yes.
Your case are twofold. First of all, they are hell bent upon rejecting yours, whatever may be, for the whatever reasons, because the two reasons are completely is different. One. Secondly, in view of the amendment which have been made by the notification dated so and so, a particular notification issued by the government of India, the persons who are up to 10 crores or so will be considered as a small.
Yes, ma'am.
So on the basis of medium, it cannot happen.
Yes.
Now, Mr. H. Gupta had made a submission on that date for which this court did not grant you an interim direction. Is look here, the petitioner did not claim as an MSME at the time of submission of his bid.
Yes, Lord.
And therefore, he was not entitled to any benefit.
Yes, Lord.
He being an enlisted had only 11 lakhs. So he
Yes,
could
sir.
not get the benefit of another 5,
Yes, sir.
another 4 additional.
Yes.
And therefore it was rightly rejected. So therefore, let us hear what Mr. H. Gupta has to say, and then we
Yes, sir.
proceed.
Yes, Lord. Yes, sir.
Yes, Mr. Gupta.
My lord, first of all, at the outset, I would like to submit that it is a case of rejection of the bid at stage 1 itself. It's a case of a defective bid. It's not a case which has gone to the stage of bid evaluation, where, my lord, that necessity of clarification as to the documents submitted can be given by the contractor. It is this bid was rejected on the ground of being defective. So, my lord, initially, when the reasons were supplied to the petitioner, my lord, at page 197, that was the first ground of rejection, wherein, my lord, not only the petitioner, along with the petitioner, 2 other bidders bids were also rejected, my lord, on the same ground, saying that, my lord, at page 200, if I may draw my lord's.
So you are not going into the question of
My lord.
medium, small, you are not going into that. Are you going into the question of medium, small?
No, under what circumstances, my lord, the facts.
Are
that-
you only on whether he applied as an MSME or not?
Initially, my lord, it was rejected on the ground of non-submission of the additional EMD, my lord. Thereafter, my lord, when he represented before the authorities, there, my lord, for the first time, he claimed at page 203, my lord,
That he was an MSME.
that he was an MSME. Then the authorities, my lord, went into that question also. And then, my lord, at my lord, page 239, that is the ground in the second time, my lord, when they rejected it. So it's not that, my lord, the authorities are taking two different stands. The authorities have considered his second request.
No, what was the necessity of going into the question of MSME or not? Whether a person, an enlisted,
My lord,
who is an MSME,
my lord.
would be entitled to total exemption if he's enlisted? That is the first question. Because your decision taken on 31-7
My lord.
is that though he is enlisted, but his enlistment was only in respect to a security of rupees 11 lakhs.
11 lakhs.
So there is a deficiency of 4 lakhs.
My lord.
But you further say that another 4 lakhs, if it is paid, it
No,
would have been different aspect to the matter.
My lord.
But he never claimed as an MSME. It is only on, as per the document at page 203,
My lord.
he has claimed for MSME.
Yes.
Now my question therefore is, if he's an MSME and an enlisted contractor, would he have been entitled to the entire exemption?
Yes, my lord. Because both
So
conditions are.
therefore, if both relates together,
My lord.
then he is entitled to. But if he has not claimed as an MSME at the time of submission of the document,
My lord.
bid,
My lord.
then he would not later on be entitled for claim.
Yes. Yes.
And therefore, clause 11
My lord.
would not apply.
Yes.
That's your
That
submission.
is exactly.
Your records will be there, his bid will be there.
Yes, I have, my lord. Bids are here, my lord. They were just upload. Brother. It,
Did you take a specific stand in your affidavit
yes, my lord.
that he
Yes.
never applied as an MSME?
Yes, yes. In the
And what
affidavit
did they
also,
reply?
and in the affidavit also, and my lord, the affidavit in reply also. And my lord.
What is this document as MSME in the
My lord,
pink
that
page?
is of a medium, my lord.
Huh?
Not of a small scale. Not of,
But how do you say that only a small scale gets it?
But that is as per the GFR, my lord. It is only the MSME who are small scale enterprise, only they are
No, as
entitled.
per that,
GFR, yes, ma'am, 2007.
only small gets the benefit.
Yes, ma'am.
As per this particular document, which is at page 100 and. But it is not that he didn't claim as an MSME.
Yes. My lord, the
So it would not be correct to say that he had not claimed as an MSME.
my lord, at the time of submitting the bid.
This is a part of the bid.
My lord, this is the part of the bid also, and my lord, I have submitted in my affidavit in reply.
Huh?
My lord, at page 300.
Where is that GFR? I could see somewhere the GFR.
Page 206, Your Lordship.
The exemption was claimed only on the ground of
Safeguard
BRO.
against the bidders withholding and so Iman issued by the Department of Iman as registered in the and Department of Interior. The bidders should be asked to furnish bid security along with their bids. Amongst the bids should ordinarily be Iman. The amount of security should be Iman. The bid security may be accepted by the form of Iman. Bid securities of unsuccessful bidders should be returned in case of bid security. Where is that in page 206? Which one is, where is it?
Sir, Rule 170, bid
As
security.
to be obtained from the bidders except micro and small.
Yes, sir.
So except micro and small MSC
Yes, sir.
enterprises, bid security is required. Okay. So he was medium, which was placed on that date.
Yes.
Okay. So, and the last date of submission of the bid is when?
16/7, my lord, 2025.
18/7, 2025.
16/7.
Huh?
16/7/25.
16/7, 2025. Now, when did the government notification come in?
As per the admitted my lord, statement, the petitioner were classified as small scale, my lord, on 1/4/25.
1/4/2025.
So even then, my lord, they have not submitted that small scale certificate. They were classified prior to the date, as per, my lord, this statement, my lord.
So you gave an opportunity at 207. This particular document is then on 7/11. What is your thing which you have said? 7/11 is there, na?
What reply, my lord, is at 204.
No, that 7/11 is when?
That is at, my lord, page.
Yes, 7/11. 7/11, this is 22/9. It intimated that during the scrutiny of TBD, it is found that your firm has not submitted the declaration as per 170 JFR and as per clause 11 of the NIT regarding exemption sought due to MSME Iman against EMD. As per so and so bid security. Was a declaration required? Mr. Gupta?
No.
Declaration is required?
Declaration regarding, my lord, the.
Can you come to page 204?
Yes, my lord.
It is intimated that during scrutiny of TBID, technical bid, it is found that your firm had not submitted the declaration as per Rule 170 Roman 3 of the GFR.
My lord.
And as per clause 11 of the NIT regarding exemption sought to MSME registration against EMD for 15 lakhs.
My lord.
As per so-and-so, bid security area is to be obtained from the bidders except micro so-and-so as defined in MSME procurement issued by the Department of so-and-so. The uploaded MSME certificate by your firm is for medium enterprise. Hence, exemption of the EMD is not applicable. As your firm is with the BSO so-and-so, exemption limitation is Iman. In this regard, in this tender, EMD sought is so-and-so and your firm has not been submitted an additional security. Now, is it required that for submitting a declaration?
No, declaration is, my lord, not required. If he is an enlisted BRO contractor, my lord, that would do.
Huh?
Because my lord, at the time of submission of the bid, my lord, they have, if I may take my lord to page 360.
But you also at clause number 11 do not say about MSc.
My lord.
You say micro, MSME.
My lord.
You
MSME
ne-
registered.
You never say MSc.
My lord, no, it says MSME registered from as per rule 171 of the GFR 2017.
so?
Yes, my lord, page 72.
Oh, as per.
As per 171.
And the MSME registered as per one of the UN, but it is required. So therefore, the document he has submitted
That was
as a medium.
my lord. Also not claimed. MSME was not claimed at all, my lord.
Then why did he submit that?
Subsequently, when he represented my lord, the authorities examined his claim, and then my lord came to a conclusion that no, you have not uploaded the MSME certificate nor claimed that benefit, my lord. If my lord takes page 67, which is the bid document, page 367, my lord. 367, my lord. The affidavit in reply, which the department has filed, my lord. Page 367.
Yes.
If my lord, in the middle, my lord may see EMD exemption details. The EMD exemption claimed is, my lord, 15 lakhs, availed exemption 15 lakhs, and my lord, EMD exemption certificate is also uploaded.
BRO enlistment.
BRO enlistment certificate.
So he didn't claim to be
He
an
didn't claim to be
MSME.
MSME. And my lord, at page 372 is the certificate which we have annexed. He is an S-class contractor. My lord will see the tendering limit.
What
is
class?
Class S contractor. Tendering limit is 1500 lakhs and standing security deposit is 11 lakhs. Page 372.
Tendering limit is 1500 lakhs.
So exemption is only up to, my lord, 11 lakhs. That 4 lakhs ought to be submitted, my lord, unless he is an MSME. But that MSME, my lord, claim was not made and no documents were annexed. You know, subsequently, that cannot be allowed, my lord.
Or there again, pre-qualification document, he have only enclosed what?
Only the
EMD.
EMD exemption certificate.
As per under document, file sets. Finance BQ.
Once the petitioner realized that, my lord, they have not
So
submitted
that certificate which he have issued,
my lord.
he should have corrected it and made it small. Then only you could have.
Yes, he could have very well submitted, my lord, because he is claiming that reclassification
No, in fact, I could
is.
see one document where you have even asked him to produce that document also.
Yes.
Where is that document I could see?
That is, my lord, annexure 13, page 219.
219. 219. Yes, Consul. In view of the above, it is requested to submit the proof of annual update details of the latest income tax details duly signed by the CACST filing area uploaded on the Udyam portal for the year 2024-25, along with all supporting documents before the date of NIT, and also submit the hard copy of the MSME certificate issued by Iman by October 10 for your further needful dear. Did he do so? Mr. Pant, did you do this as per page
Your Lordship,
220?
I, my lord, brought it to the notice that whatever is downloaded from the site, now they don't issue any hard copies. Number two things were brought to their notice. Number one, you are seeking from me these financial returns, which I can't give to you, but they are uploaded. They are 1 year previous to the last year, financial year. I have given that also. And secondly, I said, no, it is not uploaded. You admit yourself in this communication itself, yes, you have been uploaded as a small enterprise on the internet. They don't give any hard copy to me now. Everything is to be downloaded from the website only. That I have explained. As a matter of
The
fact, my
hard
lord,
copy of an MSME certificate is a printout.
printout only. That I had given to them.
Did you give a small?
Yes, that I had given to them.
No, that was of
Which
a
one?
medium. That was
Your
of a
lordship, may kindly have a look at my lord.
that is a bid document which I have submitted the flag
No,
part.
not that document.
That is.
This is after 7th of October
after the
2025. Page?
Yes, my lord. Page, lordship, thank you.
But if I remember on the last occasion, what you said that the last date for submission of the financial statement of your filing of your returns for the year 2024-25 was extended up till 31st of 10th of December. So
Yes, your lord.
at that point of time, it would not have been possible. That was your submission, if
Yes,
I'm not wrong.
that is also right. But
That's
most
but
important is
how you have to be an MSME small.
Your
Somewhere
lordship,
it is
yes,
indicated,
they
something
had
has to
to
be
be.
shown.
Yes. Your
Certificate
lordship
was
may
issued-
have a look at this communication itself. 219.
Certificate was issued when? MSME certificate, which you have enclosed.
My lord, page 236, my lord, if my lord will see the classification date. Classification date, my lord, as small, at page 236. That is 1/4/25. 1/4/25.
Where?
Your lordship can have page
Yes, they have
236.
submitted this, my lord, subsequently, my lord, after the documents, bid document stage was over, my lord. Submission of.
And this is being shown as what? Small?
Small.
Where?
Your lordship may have a look at central column. Number 1 is the classification area is 2025-26.
At medium, page 232. You are saying about 235.
Yes, my lord. 236.
236.
Yes, my lord.
Type of enterprise small 1/4/2025.
Yes.
So this
No,
document,
your
when you
lordship may,
wrote it,
for a moment, your lordship may revert to my lord, page 219. Your lordship may kindly see my lord para 2.
in this kind, as per government gazette notification on verification of your MSME on Iman, your has been showing as small enterprise. Was that?
They admit.
But this is already there.
This is already there. And they had reopened the entire issue, thereafter rejected on
And
the
these
ground
are
that
e-certificates.
No,
You are to
you
take.
have
not whether they have claimed that exemption while submitting the bid, my lord. They have not claimed.
So you therefore don't stick to anything else.
My lord.
You say that your basic case is defense is that look here, he never claimed. He claimed EMD exemption on the basis of the enlistment certificate,
my lord.
but not as an MSME.
Yes,
Because he never included that document
yes.
at the time of submission of his bid.
Yes, my lord.
Yes, Mr. Pathak, what do you have to say? You have nothing to say.
My lord, this documents your lordship has seen as far as the MSME claim is concerned. They were supplemented later on, my lord. After the bid procedure was over, they were supplemented later on, my lord. Can these be now read as part of his bid?
No, but it's a different thing. But by virtue of 219, they have permitted him to submit.
They did not permit.
Yes, kindly see.
asked, my
No,
lord,
kindly come to
do you
page.
have it?
No, 220, see, 220.
219 is not a decision, my lord.
Yeah.
By 220, this was the direction being given.
Right.
In view of the above, it is requested to submit the proof of annual update details of the latest income tax details duly signed by CA and GST, filing information uploaded on the Udyam portal for the year 2024-25, along with all supporting documents uploaded before the date of NIT. All supporting documents prior to the date of NIT. And also submit the hard copy of the MSME certificate issued by you by Udyam Registration Authority by 10th of year for our further needful.
Then at page 235, my lord, on 10/10 they submit. Thereafter, the decision is taken. 19, that page 219 letter is not the decision, my lord. That's all.
No.
Asking
So
them to
therefore, the authority, authority considered and granted an extension for submission of the document, MSME.
pension is not expected.
Then why was the authority asking him? They should have
That
finished
is
it on
the second-
31/7,
My lord.
cut off.
No, Lord.
You are engaging with him. That look here, you give me this, you are shown as medium and all these things and all. And thereby,
Because the stage of
That was
clarification
only,
supposed in July.
no, that was only because he has submitted in along with the bid document, one of the certificates, which was MSME.
understood. So therefore, when he has asked it, why on earth did you pass this order on 7th of October 2025?
Then, my lord, ultimately, when a decision was taken by 7-11, no, the reason was due to non-producing of the hard copy of the MSME certificate.
And
my lord-
that 7-11 is where? Due to non-producing hard copy MSME certificate of small category.
No, Lord.
Non-submission of proof for uploading of updation on MSME registration. But you know it, that it is small.
No, my lord.
This is already written in page.
When, my lord, petitioner has not claimed it as an exemption on the ground of small, my lord, how can the authorities know, my lord? It was only when initially rejection,
Therefore, you should have stick to 31/7.
my lord.
You should have stick to all these things. But are you not opening up many loopholes on your part? That by saying that, look here, you have an MSME certificate, kindly provide this up to date. A certificate to that, a hard copy to that. And the rejection ground is you have not provided you the hard copy. Whereas at page 219, you say, in this connection, it is intimated that as per a government notification and on verification of your MSME on Udyam portal, your certificate is shown as small enterprise. What you need is a hard copy only.
The fact of the matter is that, my lord,
But
since
Mr.
they have
Gupta,
not
tell me,
claimed
in view of the
exemption-
Information Technology Act,
my lord,
isn't the Udyam certificate, the MSME certificate a digital document?
but the ground of rejection remains the same, my lord, that non-submission of the additional, since they have not claimed as an MSME, my lord, that the grounds for rejection remains the same.
But
that is
the
non-submission of the
but the
EFT.
subsequent submission is this. Why on 7-11 you rejected in these terms?
So that was only, they have not taken a final decision, my lord, that since he has submitted.
No,
some-
kindly see page 239.
My lord.
Reason for disqualification is due to non-producing hard copy of MSME. Now, how do I hold this to be proper when this very certificate is a digitally signed certificate? Isn't the MSME certificate digitally signed? Yes, it's a digitally signed document.
But the main grounds remains the same, my lord. Again, my lord, the original grounds. That does not get substituted, my lord.
Huh?
The original grounds for rejection remains the same. My lord, non-submission of the additional security. Had, my lord, at the time of submission of the bid, he would have claimed as an MSME, my lord, perhaps the points which now been argued, my lord, would have been taken into consideration. But since, my lord,
But the points have been argued because of the fact that you permitted.
my lord, that may be an error on the part of the authorities, my lord, but that's, my lord, ultimately the entire tender process has to be, my lord, evaluated. And there are not only his bid, my lord, there are other two bidders also. On the same ground, the rejection was made.
Where? So then we have to set aside the entire thing for going for fresh tender.
No,
If
no,
we
if,
set
my-
aside.
no, in that case, they will be.
Now, if we
there-
have to set aside, then it would prejudice those two persons also.
In that case, if it is set aside, my lord, then it will be evaluated, my lord. Their bid will be further evaluated. Whether they will, along with the other bidders. Although.
Difference between L1 and my bid is 84 lakhs.
Huh?
Difference between my bid and the bid of the L1 is 84 lakhs.
The bid has not been opened also.
No, I know my financial bid.
He knows his bid. That is why he's fighting.
We don't know. Madam.
Chalo, we do one thing. We keep this matter on 17th of February for final disposal.
Obliged, my lord.
This matter on 17th of February 2000. This court have heard the learned counsel's appearing on behalf of the parties at length. Mr. H. Gupta, pursuant to the order passed by this court, have also produced the bid document which was submitted by the petitioner. It is a case of the respondents that the petitioner at the time of submission of the bid did not claim exemption of the EMD on the basis as in the capacity as an MSME. In the capacity as an MSME in terms with Rule 170 bracket small I of the GFR. And as such, the petitioner having being only an enlisted contractor having a security deposit of rupees 11 lakhs, the EMD so submitted by the petitioner, the non-submission of the EMD had become fatal to the case of the petitioner. This court inquired with Mr. H. Gupta appearing on behalf of the respondents' authorities as to if that be the case, why the respondent authorities engaged with the petitioner as regards the MSME certificate and further by the communication dated.
It is 7th of October 2025, page 219.
Dated 7th of October 2025, asks the petitioner to submit certain documents, including a hard copy of the MSME certificate, wherein, and more particularly, when in the very document itself, the respondent authorities have categorically mentioned that in the website it is seen that the petitioner is a small enterprise. This court also inquired with the learned counsel appearing on behalf of the petition respondents that the rejection so carried out on 7/11/2025 is based upon two reasons. First, non-submission of the bid document, non-producing the hard copy of the MSME certificate of the small category, as well as non-submission of the proof for uploading an updation on MSME registration authority. This court inquired with Mr. H. Gupta as to whether the learned counsel as to whether after admitting that the petitioner is a small business, small enterprise in the communication dated 7/10/2025, and the submission of the MSME certificate for the year 2025-26 downloaded from the Udayam registration portal on 10/10/2025, wherein the petitioner has been shown as small enterprise with effect from 1/4/2025. Would the reject disqualification on the basis of non-submission of the hard copy of the MSME certificate holds water? Full stop. Further to that, this court also inquired as to whether the non-submission of the proof for uploading of the updation on MSME registration certificate was at all necessary when the petitioner had, pursuant to the communication dated 7/10/2025, have already produced the MSME certificate showing the petitioner was a small enterprise with effect from 1/4/2025. Footstep. In that regard, the learned counsel appearing on behalf of the respondent submitted that he would obtain instructions in that regard. List the matter on 17th of February 2026 for further instructions, for further hearing.
Obliged, madam.
Mr. Gupta, you have a big problem on this. You have open Spender's box.
This respondent has not yet issued LOA notice. Let us know if we maintain notice.
You got an LOA?
Not issued.
Not issued, my lord, I am waiting.
Wait.
There was no stay, but then they have kept it on.
Dispose of.
I fix it on 17. You get it at a lesser price, have it. But the only problem is, if it was the first ground itself and you would have stopped there. And you see the second grounds and you have opened up box, opened up way, and then you have taken another ground.
What I see is that in September, my lord, they first time wrote a letter based on which this correspondence was issued. They
See,
informed for the
no,
first
no,
time
you
that
see,
we
no,
are.
Mr. Counsel, you have to see, AFCON says, we are not nobody to say anything. But they opened up. After opening it, now therefore, we have to look into it as to whether it is proper, taking into account on 10/10 he has submitted the document. Chalo, anyways. Mister, you need it? We'll keep it on.
My lord,
record.
can keep it, my lord.
The bid so submitted by the petitioner is also kept on record, my lord. The copy of the bid which was submitted by the petitioner is kept on record. Yes, what
Obliged.
is this?
In this case, petitioner was appointed as a stenographer grade 3 while advertisement dated 25/8/2010. He was appointed and in that advertisement, he was offered grade pay of rupees 5,200 to 20,200 and grade pay of 2,400. But after joining his job, his pay was given this 5,200 to 20,200 and grade pay was 2,100. And after this, he made a representation about his pay scale and he was given back a reply that he has not provided the certificate in which it was given that his institute was a government recognized. But Lordship, in Annexure 11, page number 24, principal of the institute has given a certificate that says that so and so institute Bangladesh government registered firm and Guwahati Disport, it is a government recognized institute. Actually, for this reason he was being given pay of this rate of 2,100. Lecture 1 is the advertisement, which clearly says pay scale should be PB2 5,200 to 20,200, rate pay 2,400.
Kindly come to paragraph 11, page 36, running page 36 of the affidavit filed by the government. That with regard to the averment made in paragraph number 9 of the report, the deponent begs to state that the petitioner has been appointed by the deputy commissioner in the scale of underqualified stenographer, that is 5,200 to Iman. he has been paid rupees 6,900 GP 2,400 per month and other allowances as per his entitlement in the month of May 2003. Now you are getting it. Now, who can find out that this ITI, this Apollo Institute is a government recognized institute? It's only on the basis thereof it has been rejected. Who can register give this government recognized institute? Where is your certificate? That he is a government recognized certificate institute?
Lordship, page number 24, answer 11. The principal of the institute has certified that.
What?
This is to certify that Apollo Common.
No. Can the principal say that I am government recognized? Who will recognize you? It will be done by the government, isn't it?
Yes, Lordship.
Is it
Registration
today?
certificate may be
Today,
there.
tell me whether the bar council will recognize a college or the college principal will say that bar council recognizes me. Who? Then this is the most vital aspect. The matter is pending unnecessarily from 2018. Short point.
Yes, Lordship.
He is not produced.
Not produced.
Then he cannot say that we are recognized. Is a government recognized in respect to the course of year? Where is it? Bongaigaon. Apollo so and so, he is only giving. There is nothing on record. Bad case. Hello. No documents has been produced. Yes, Mr. C. Borua. Is it possible for the owner of that institute to say that we are government recognized and this court to believe that?
No. Yes.
Hello. Dismissed.
Matter related to seniority.
What?
Seniority.
Seniority.
Seniority. Yes.
Affidavit file, reply file.
I not find reply.
You want to file reply?
Next week.
The counsel appearing on behalf of the petitioner submits that he would like to file a reply to the affidavit in opposition filed by the respondent number 2A. To list this matter again on 8th of May 2026. In the meantime, the reply be filed by the petitioner. Other respondents would also be at liberty to file their reply, the affidavit in opposition on or before 27th of April 2026. Is given the final liberty. What is this? Mr. Gogoi, what are you on this side?
My lord.
Something must be seriously wrong.
Yeah, my lord, see, little accommodation for today, my lord. 18 matter. I had this file only few days back.
Don't worry, I will accommodate you. Mr. D. Gogoi, what is the ground I should put?
For reply.
There is a reply, reply has to be.
That
given
would
to
be
the-
poor. They filed the affidavit in opposition in 2018 and to give you after 7 years time for reply.
Then, my lord, I'm legally engaged.
By which terminate the service. Your service has been terminated. Chal. What is the ground?
My lord, we can only give you a summary, my lord.
You give me only 2 lines.
He acquired some deformity, of medical nature during when we was undergoing training. And there was a review medical board held, my lords, which without taking into consideration the disability, then he could have been assigned some other duty also. He was declared unfit for duty and terminated. It will-
And it was not communicated to him.
Medical report of benefit form.
When did you join?
On 26/7/2017, madam.
And in 2018, this has happened during the probation period.
Yes, training.
Okay. The learned counsel appearing on behalf of the petitioner submits that though the respondents have filed the affidavit in opposition, but the petitioner have not been able, the counsel have not been able to, has been newly engaged. And it is his opinion that the petitioner would be well advised to file a reply. So considering the above, list this matter again on 11th of May 2026. In the meantime, a final opportunity is given to the petitioner to file the reply on or before 4th of May 2026.
Lordship, Lordship, I have a prayer in item number 10, the pen drive I have given. There are some other datas also. I will take this and give the video data on.
You put it, give me a pin drive somewhere,
Lordship.
or get a pin drive somewhere from somewhere and copy and paste and give it to me.
Lordship.
Because I have to keep it on record.
Lordship,
Because
I will give
tomorrow
it
an
because there are
appeal will
some
be filed.
in my
And
person
Mr. What is his name? AR? Oh yeah,
Lordship, I will give.
he'll be the first thing to file the appeal.
Lordship, I will give it, but there are some other datas that I will collect, erase it and give it, Lordship.
17.
All affidavits filed. What is the matter pertaining to?
Granting of VRS benefits, my lord, to the petitioners. So they were,
16 employees of APDCL.
yes, my lord.
VRS, voluntary retirement.
Voluntary retirement, my lord.
Matter has been pending for 4 years and you are still functioning. You have been voluntarily retired. Benefits not granted.
The organization has itself been winded up in last year.
Okay. Mr. So-and-so appearing on behalf of the petitioner submits that the petitioners have already been granted the voluntary retirement. You got it? But the benefits thereof have not been provided. But a prayer is what? Another please to call a year should not be issued directing the respondents to revise the pay of the visa on the 6th and 7th day and to arrange for area of pay and allowance to facilitate VRS of the 16th. We have not got VRS. Voluntary retirement settlement. What is VRS?
No, there is a voluntary retirement scheme that was propounded by the corporation. Now alleging non-payment of that voluntary VRS benefits, this writ petition came to be filed. Now during pendency of this writ petitions, my lord, they had moved a proposal to the finance department. They were supposed to move a proposal to the finance department, my lord, seeking my lord, an amount of rupees 4 crores for in the nature of my lord, for supplementary demand. So as to my lord, budget, my lord, VRS benefits.
Who has moved?
My lord, the administrative department concerned, that is the soil conservation department. And on the last stage, if lordship may be pleased to peruse the last order, my lord, 1st of December 2025, last order. I had placed an instruction on record.
So therefore, this 4 crores is admitted.
4 crores, my lord.
These are admitted. But there is no final budget.
Yes, my lord, so far
Simple issue.
so far as the
No. But therefore, my question is, when the administrative department have admitted the dues and moved the proposal for payment, the amount is already admitted.
Yes.
They are entitled to some 4 crores or something.
So 4 crores is the final limit. My lord, they are entitled to, my lord, 1 crore 70 lakhs.
Okay,
1
1
crore
crore 70 lakhs has been duly admitted.
Yes. They
Now,
were-
therefore, the question is the finance.
No, finance, they will have to move a FOC proposal because for releasing the money.
Understood.
Yes.
So therefore, the question is the finance, the budgetary ceiling not available or the budgetary provision not being available for making the payment. So therefore, they have moved a supplementary demand.
Supplementary demand now.
And with the supplementary demand being given, then only the petitioner will get the money.
Yes, now that formally that has that is not forthcoming from the administrative department. That is the, my lord, instruction that is placed on record on the last occasion. Therefore, this honorable court was pleased to pass that order.
Have you sent the FOC?
My lord, the thing is that the Standing Council of Soil Conservation Department, SR Rabha expired recently. So my lord, department has
We had a reference also yesterday.
My lord, this is the instruction sent by the department.
The Soil Conservation Department may appoint after 2 years. Should we keep it for abeyance?
My lord, soil conservation also.
Okay, we do one thing, nothing doing. We get the we only want the instruction.
My lord, yesterday I.
No. If you are nobody, who are you? You are
My
not.
lord, I assisted SR
Okay,
Rabha.
then it's okay. Government? It has been brought to the attention of this court that the Standing Council of the Soil Conservation Department, who was appointed, had expired. And the Soil Conservation Department is yet to engage any other council. Considering the above, it being a department of the government of Assam, this court have asked Mr. D. Nath, the learned senior government advocate, to correspond with the Soil Conservation Department of the government of Assam as to whether the FOC proposal of the approved amount have been placed before the finance department. List this matter again on 25th of February 2026. The name of Mr. D. Nath, then its senior government advocate, be shown in the cause list. You get the instructions. Opens,
But the age of the termination of the prisoner.
Huh?
That should be a pressure under.
You have superannuated? You have superannuated?
The super attained the age of 60 years, but the case of the prisoner is that it should be 65 years as per the decision of the government. The government has increased the age of superannuation of professors to 65 years.
Ah.
But that benefit extension of age of superannuation has been denied.
Okay. Affidavit, so many pleadings.
Yes, my lord, that was also heard, my lord. The judgment reserved but could not be delivered.
Who has heard?
No, my lord, they are coordinate matter.
Obviously, it's a single bench matter. And it cannot be the division bench have heard and could not deliver the judgment. Anyways, we do one thing. Anyways, I can't take up these matters, finish off. I think. Okay.
My lord, this is.
Matter is urgent, no? When did you superannuate?
2024 February, he attained 60 years.
Okay. Huh?
And 60 years he has attained, but cause of action will continue till he attains 65 years because petitioner is claiming that he should be get the benefit of 65 years, which has been enhanced.
Because then if it is being increased, it would be a case of compulsory retirement.
My lord.
If it is not granted the benefit, it would be a case by which the government have not acted in terms with 56B. Isn't it?
Yes.
The petitioner says that the respondent number 5 organization, they should take a decision to increase the age of retirement up to 65 years. The decision of the government is that for the institution, retirement age is 60 years. Government has
Yes.
taken it.
The
Sure.
land is there, it is not
The counsel appearing on behalf of the petitioner submits that the matter requires an urgent disposal, taking into account that in the year 2024, on account of the petitioner having completed 60 years, he had been retired. He had been superannuated, though the age of retirement of a professor
professor,
in a university
not in university, all at.
or a professor as per the UGC or as per the government.
Ordinance pursuant to cabinet decision and.
Person of the government of Assam is 65 years.
So that is pursuant to.
He therefore submits that this is a case where the benefit of the petitioner have not been granted and as such requires an urgent disposal. List this matter on 10th of March 2026, on which date, for 10th of March 2026, liberty given to the petitioner to mention the matter for upgrading.
I'm applying.
On which date an attempt shall be made to dispose of the writ petition, liberty given to the petitioner to mention. A.Y. Chaudhary secured 12 point, but there is no intimation given by the respondents herein as to whether the petitioner would be recommended for appointment.
Well, I have received the instructions. no?
Shocks has warranted the respondents have not placed the instruction till date. A perusal of the orders passes. Okay, so you got your instruction?
Yes, my lord, I have received it.
See?
My lord, my instruction
Like
says,
this. With reference to, I have to inform the notice of the Department of India with the CFA we are recommended to the party qualified.
well, the final merit list, lordship will find that that is 22nd of May 23. Here 362 persons are there. They were selected after the written and the medical examination. The roll number of petitioner doesn't reflect.
This is for what examination?
For
This is all for persons with disability.
yes, my lord. It was a special recruitment drive for persons with disabilities to fill up grade 3 and grade 4 post.
So 362 persons have been done.
Yes, they were selected.
Select list was published on 22/5/2023.
23.
And the petitioner's name was not shown.
Not there.
So the
Not-
petitioner therefore is not qualified unless you challenge this notice.
Yes, my lord.
Matter over.
Yes, I'll
Okay,
give.
don't
I'll
worry.
give.
Heard Mr. A.Y. Chaudhary, the learned counsel appearing on behalf of the petitioner, Mr. D. Nath, the learned senior government advocate who appears on behalf of the respondent numbers 1, 3, and 5, and Mr. R.C. Alom. Who is he? Who appears for respondent number 4? You appear.
Four
Mr. P.J.
here.
Pukon appears on behalf of the respondent number 4. The grievance of the petitioner herein is that he applied pursuant to an advertisement dated 30/12/2018 for the post of grade 4. Full stop. However,
Can you see para 8, my lord, of the writ petition, page 7? He says that his serial number is 1961.
wait. The petitioner, as a person with disabilities, have applied for a post of grade 4 against the advertisement dated 30/12/2018. It is the case of the petitioner that pursuant to his interview, his participation, as well as the interview held on 24/2/2021, the petitioner was put in the merit list for grade 4 post for the person with disability (blind and low vision candidate) and was put at rank 1961. The grievance of the petitioner is that thereupon no further action has been taken for which the petitioner had submitted a representation on 1/5/2024. Which continues to be pending. And it is under such circumstances the instant writ petition was filed on (25) 2024. The record reveals that by an order dated 19/8/2024, notice was issued. Thereupon, when the matter was listed on 29/1/2026, this court inquired with the respondents as to why the petitioner has not been recommended for appointment or pursuant to the claim that the petitioner was at serial number 1961 in the merit list. In pursuance thereto, the Mr. D. Nath, appearing on behalf of the respondents, numbers 1, 3, and 5, have placed before this court an instruction dated 5/2/2026. The same is kept on record and marked with the letters X. Full stop. It is mentioned that a medical examination was conducted for persons with benchmark disabilities for candidates recommended by the Guwahati University for recruitment in grade 3, grade 4 post under the special recruitment drive for persons with disabilities. Full stop. The petitioner, however, was not selected in that regard, and this aspect would be apparent from the notice dated 22/5/2023, which was issued by the Department of Social Justice and Empowerment. Taking into account the above, it is the opinion of this court that the reason as to why the petitioner was not recommended appears to be that the petitioner was not selected and his name, roll number was not selected. Under such circumstances, the cause of action for which the instant writ petition was filed no longer further survives. Sends a challenge to the select list, if so permissible under law. Considering the above, this court therefore dismisses the instant writ petition. Full stop. Liberty, however, the dismissal of the instant writ petition shall not, however, preclude the petitioner to avail remedies to challenge the select list if so advised, and further being permissible under law.
Transfer and booking. The petitioner is a 50% locomotive disabled person, and he has employability restriction with regards to hilly area and cold climate. But without taking into consideration that fact, he was transferred to Jammu, a place called Nowshera. He was transferred, which is admittedly a hilly area and extreme cold climate.
Where?
Nowshera, Jammu.
Jammu, where? Nowshera.
Nowshera.
You've been there? You've been there?
I don't know.
Then why are you making the submission?
As per the letter.
What?
Stated that whether in
Jammu Tawai. Jammu Tawai. Jammu area is good. It's not like Kashmir. Then what is there?
He's 50% locomotive disability.
So
he from the leg down, he need a crutch to walk. He cannot walk.
he can work there also, plain areas.
But there is employability restriction is there.
You got a status quo.
Yes.
Sir, because of the interim order, he is continuing.
Huh?
He is continuing in the present place of.
Understood, but this is a good the station. You
But
should go there.
a similarly situated person is serving in that place where the present place of posting.
case-
It is a hairy, not a hilly area,
The
but
judge who must have passed the status quo order must have thought, oh,
my lord,
Jammu Tawai. Jammu Tawai, train also goes.
Train the area which he is posted.
And from there, after Jammu Tawai, there are certain hills.
From the place which he has been posted is around 100 kilometers, 114 kilometers from Jammu railway station. It's a VRO.
What is your stand, mister?
my lord, 172 my lord.
Huh?
Of my APDB, my lord, posting from
Where are-
and to soft area and hard area. It is categorized. Chapter ROI, my lord. Chapter 24. One. One 179, posting to, the following point will govern the posting from and to hard and soft area. No medical bar. No age bar. No age bar, no medical bar.
Where?
Hard area. And where he was now the authority want to transponder was passed to the hard, it is a hard area, my lord. My lord, notification, my lord. At ROI at 166, my lord, of my APDP, my lord.
You put him to Nagpur, the most plain area.
Plain.
Put him to Nagpur.
Sampak,
There
my lord,
cannot
is
be any more plain area.
plain area, more,
Isn't it?
plain area, my lord.
In India, the most plain area is Nagpur. Even Rajasthan may have sand dunes. Nagpur won't. Put him to Nagpur, nearby Nagpur, all these areas. There's no hills, nothing.
My lord,
Then you don't have a right out there.
Lordship, I take your lordship to,
What is your right not to be transferred?
I'm not saying they cannot transfer me. My point is, there is some employability restriction given by the board that I cannot be transferred to certain areas where there is extreme cold climate or where there is
There is no clone climate in Jammu Tawai.
their own welcome letter expedia there, cold climate. Their own welcome letter by the authorities.
Where?
I,
You must have enclosed it.
Lordship, I have got it today itself.
Today only you have got it.
This one I got it. If Lordship directly, I file via affidavit only.
To me, welcome. Why they have given a welcome after a status quo order?
No, this was given, the client has given me this today.
Welcome letter referred.
The
I
Lordship,
have,
weather condition is down east.
I on behalf of ranks
weather
of
is
this
not
week,
only very
welcome
hot,
to
summer is very
inform
cold in winter.
in the following.
And woolen clothes are required. The transportation also is not fully. Department of vehicle available from Jammu Tawai railway station only on Monday. Civil bus tempo traveler. The location is also, the location is about 114 kilometer away from Jammu Tawai railway station. It is not on Jammu. It is away 114 kilometers away from Jammu Tawai railway station. Moreover, Lordship, there is also no availability of married accommodation is also not there. I, being a locomotive disability without my wife, without any accommodation, only civil accommodation is there.
What is ADS?
ADS is this is dental medical facilities. This is Army Dental Hospital. There is one Army Dental Hospital.
With this hot in summer and cold in winter is always there. Even in Delhi, it is very cold. Then
The medical facilities also are like very restrictive there.
they say that the medical facilities are available. Kindly see at paragraph number 13 of the affidavit in opposition.
Yes, 13.
Public Health Center, medical office available. 329 Army attendant medical and surgeons available. It is not out of case that at least 153 employees were having low medical theories such and so are available. Then
Take my medical restriction at page number 46.
40,
Page number 46.
46.
Yes.
Yes.
The medical category now recommended during with duration Ref 3 E3 permanent.
Where?
Top Lordship, medical condition, page number 46.
Top.
Ref 3 P3 permanent. First,
P3 permanent. What is that P3?
yes. Page number 134. Fit for sedentary duties in area where hospital with appropriate specialists are available nearby, not fit for hilly terrain. HAA and
P3. Psychological hearing appearance. Which one? 134.
134 physical P3. Categories. In the category. physical
Hilly
category,
area not fit for
hilly terrain.
and
HAA, HAA and ECCA.
what is ECC?
ECC is extremely cold climate area. Lordship might take my doctor's recommendation, which is at page number 147 by Teshpur Medical College.
So put into a hot area, Nagpur.
My lord, I have stated in para 13, my lord.
They are
We have
CREF, na?
few places, my lord. Otherwise, all the units are located along with the borders and high altitude area.
Okay, put him in Gujarat, Kutch area, that is also border. More plain, white sand.
But other person is a person working there, my lord.
What to do? Your medical people are doing all these things. Anyways, you have filed your reply to the affidavit?
Lordship, I'll file it for now.
Hello. That Mr. F. Faridi, appearing on behalf of the respondent, submits that he would like to file a reply to the affidavit in opposition filed by the respondents. And also enclose certain documents which has come into his possession in the meantime. List this matter again on taking into account that there is an interim order passed whereby the state's transfer of the petitioner have been stalled. This court fixes this matter again on 25th of February 2026.
Okay. Because I'll be out of station the last week.
26th.
On 6th of February, 6th of March.
On 6th of March 2026. Final liberty given to the petitioner to file reply by 2nd of March 2026. So the interim order passed earlier shall continue till the next date.
My name may be recorded, my lord.
Oh, your name will be there. Mr. A.K. Datta has strongly opposed.
Otherwise, some problem is there.
Yes, what is this, Mr. Faridi? Another matter.
This application is basically.
Lordship, this can be disposed of in view of the prayer made in. Lordship may kindly come to page 22. 21. He want to stay in the quarter till 31/3/2026. So one more month, let him stay and the matter may be closed, Lordship.
For retention of the government merit contract till 31 Iman in accordance.
when in
with the
February,
office
Lordship.
Memorandum dated another year. So he wants only till this.
That's it.
Okay. The
Lordship.
counsel heard Mr. F. Faridi, the learned counsel appearing on behalf of the petitioner, and Mr. B. Chakraborty appears on behalf of the respondents. the learned counsel appearing on behalf of the respondents upon instruction say
No,
submits.
Lordship, we contested the case, but since.
No,
now
no,
only
upon
one
instructions submit that taking into account that the petitioner's limited prayer is for retention of the government merit accommodation till 31/3/2026, the respondents herein would not further contest, provided the petitioner herein would vacate
immediately.
vacate on or before 1/4/2026.
Oblige,
Full
Your
stop. Mr. F. Faridi appearing on behalf of the petitioner submits that the petitioner would vacate on or before 1/4/2026. Full stop. Taking into account the above, as well as taking into account the said submission, as well as the prayer made in the instant writ petition, this court therefore disposes of the writ petition with a direction upon the respondents to permit the petitioner to retain the government merit recommendation till 31/3/2026. This court further directs that the petitioner shall vacate the government merit accommodation on or before 1/4/2026. Failure to do so, it shall be construed as a violation of the provision
And will be
of
at
the
liberty,
orders passed
Lordship.
by this court.
Will be at liberty to take.
So in addition to that, the respondents shall also be liberty to initiate appropriate action.
As per law.
Yep.
Oblige. Your
My lord, the employee of my lord, Community Center for Education, Labor.
What do you want?
My lord, are identical, my lord, to the state government employee, such as a state government employee.
Lordship, welfare board is the necessary party, Lordship. Respondent number three
Three
and
and
four,
four.
they are the necessary party here, Lordship.
They are there.
Yes, Lord.
They are there.
Three and.
You're
yes.
three and four.
Yes, Lordship, I'm on behalf of Mr. P. Hazarika, actually, Lordship. Lordship, we need some
Counsel
time.
appearing on behalf of the respondent submits that the affidavit, some more time is required for filing the affidavit. Consequently, this matter again on 16th of March 2026. In the meantime, we'll file affidavit.
Yes,
The respondents
Lordship. I have been asked to seek time, Lordship. They will.
will file also.
I shall file, Lordship.
In that view of the matter, list the matter on 23/2026. In the meantime, the respondents are given the liberty to bring on record the stand by filing the affidavits on or before 16th of March 2026. The interim prayer shall be considered on the next date. There is no interim prayer sought for here. What do you want?
My lord, my salary, my lord, since
What?
pensioner salary, my lord, since August 2018 to, my lord, December 2018. was not paid.
The payment of salary and other allowances to the petitioner as per the recommendation here. You are not receiving pay salary.
Yes, for the last five months. August,
Good stuff.
August, my lord.
No, okay. We prepone it. You file your affidavit. We have it on 13th of March. You file your affidavits on so and so. Good stuff. Mr. So and so, the learned counsel appearing on behalf of the petitioner submits that the interim directions may be passed. Certain interim directions may pass, taking into account that the petitioner have not received the salaries for the last 5 months. Full stop. The respondent shall, without fail, bring instructions before this court as to whether the petitioners are entitled to salary, and if not, and if so, why the payment has not been made for the last 5 months, as alleged by the petitioner. This court shall further consider, on the next date shall consider as to whether interim directions are required to be passed upon the past.
Lordship, in this case, I have received the
Yeah, medical board, what is this? Unfit? Any instruction?
Vitiligo, Lordship.
Huh?
Penal vitiligo. Vitiligo, Lordship. This is
What do you want? Vertigo.
sometimes may be granted to file affidavit, Lordship. We are supposed to.
So there is an interim order.
Yes, Lordship.
We have asked you to bring on record a specialist opinion.
Yes, Lordship.
You are not interested in early disposal.
Yes, Lordship, but since there was an order to file the affidavit, Lordship, and I have received Paraguay's comments only yesterday,
Ms.
Lordship.
RDB appearing on behalf of the the learned CGC, who have submitted that she has already received the instructions and would be filing the affidavit in a week's time to establish this matter again on 23rd of February 2026. The affidavit be filed on or before 18th of February
Yes.
2026. Liberty given to the petitioner to file a reply thereagainst. Interim order passed earlier shall continue till the next date.
Obliged.
May I please, Lordship?
Results not issued, why?
Yes, Lordship, from the Office of the Director of Social Welfare, the instruction is awaited, Lordship. Otherwise,
Did you ask for?
yes, Lordship, we have communicated.
Then also he has not.
The instruction,
We do one thing. He actually doesn't want the help of the government advocates. We ask him to appear in person.
from CDPO, I have received.
What is that?
As per their CDPO, the pending of the WP1 writ petition, the result is not declared as per CDPO, Lordship. He communicated to Office of the Director, Women and Child Welfare, but
Because we need the small issue. It's
yes,
only.
Lordship. Kindly fix the coming week, Lordship, next week. Yes, litigation to the pending as that.
What is this Anganwadi you are asking for?
Anganwadi worker matter.
Name.
Name, my lord,
Kumari Gati Anganwadi Center has been forwarded to the Office of the Director for approval. I would like to inform you that the result can be published only after the approval of the Director. A copy of the letter dated so and so. They would like to inform you the selection for the above mentioned will be submission to the complaint result filed by one of the in the Guwahati High Court and so and so. Okay, so they have selected some, looked into and found one person. So I would like to, that the name of the selected candidate has been forwarded to the director. But there is a case pending and therefore nothing has happened. Wait, let me do it. Pursuant to the order passed by this court on 9/1/2026, an instruction has been placed before this court by Ms. S. Burwa appearing on behalf of the respondents, where issued by the Child Development Project Officer, Mankasar ICDS Project Jungle, which is kept on record and marked with the letter X. From a perusal of the said document, it appears that the name of the selected candidate for the post of Anganwadi worker of Sahib Bhui Kumargoti Anganwadi Center have been forwarded to the Office of the Director, Women and Child Development Assam for approval. It is only upon the approval the results can be published. It is further mentioned that the selection procedure for the above mentioned post is under subjudice in another proceedings being WPC number 3532/2025. Considering the above, lists this matter on 9th of March 2026 along with WPC number 3532/2025. In the meantime, the respondents shall bring on record their stand by filing their affidavits.
Obliged.
Can you see the last number?
Yes, 165.
Yes, Lordship.
By
Kindly
the
fix the
final
letter.
direction, it should be. Yes, why you are not allowing it?
Is SS Roy is leading this case, Lordship. He has left the court from.
So?
Kindly fix next week, Lordship.
No instructions have been placed pursuant to the order dated 31/2026 on the ground that the instructions which have been given was handed over to Mr. SS Roy, CGC, who is not available when the matter is called. considering the above, list the matter on 11/2/2026. Miss. Okay, that's all. Admission? Admission? Arrested. Yes, what is this? Suspended from service. How long are you going to suspend him?
Lordship, Lordship, I have received one internal communication, Lordship. Subsistence allowance has been received, Lordship, as per this instruction.
You have given the subsistence allowance.
Lordship, as per this instruction.
Now, what is his prayer?
Non-release of subsistence allowance, Lordship.
You have been paying now.
Lordship.
Under the amalgamated so and so has been suspended with effect from Iman to so and he has by sanctioned subsistence. The subsistence allowance has been given to you, so nothing remains.
Yet to be received.
You'll get it. It has already been sanctioned
On
on 31/12.
31/12.
We make it a point that this is the period how it is being given to be disbursed within 15 days. Mr. Counsel, as regards this, if not yet disbursed for an earlier period from 1/8/2025 to 31/10/2025 or till the month of December, you do it within 15 days. How will you survive? As regards the remaining, it will go as per month. Okay? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. H. Chakraborty appears on behalf of the respondents on call. The petitioner herein is aggrieved by the fact that the petitioner has been put under suspension by an order dated 1/8/2025. However, the petitioner have not been paid the subsistence allowance to which the petitioner is otherwise entitled as per law. It has been brought to the attention of this court that by an order dated 31/12/2025, the subsistence allowance of the petitioner has been sanctioned in terms with FR 53(1) Roman 2 small a of the FR and SRs insofar as the same is applicable to the state of Assam. The order is kept on record and marked with the letter X. Mr. So-and-so appearing on behalf of the petitioner, however, submits that though there is a sanction, but the petitioner have not received the subsistence allowance. Taking into account that there is already an order of sanction of the subsistence allowance, the respondents herein are duty bound to make payment of the petitioner of the subsistence allowance as not only as per law, but also as per the order dated 31/12/2025. Accordingly, the instant writ petition stands disposed of with the direction upon the respondents, more particularly the District Commissioner Borpeta, to take appropriate steps for releasing the area subsistence allowance for the period from 1/8/2025 till 31st of December 2025 within a period of 15 days from the date a certified copy of this order is served upon the District Commissioner Borpeta as regards the remaining amount, as regards the period from 1/1/2026 onwards. The same be done every month as per law. So in that regard, the district commissioners shall within 2 months file an affidavit of compliance before the court. Yes. Contempt, all these things. What is there? Ireka. What is there? This is why the matter has come, because this court has fixed it. Okay. We do one thing, can't help it today. 28, 29, 30, 27, 28, 29. We fix another date. All contempt matters. No rejoinder file, matter to be listed on other, no rejoinder file, it is 31 to go, 27, 28, and 29. We have it again on 16th of February. 27, 28, and 29. 31st, item number 31. Taking into account that the petition no rejoinder affidavit has been filed, comma, the instant writ petition, it shall be deemed that the pleadings are complete, and accordingly, the matter shall be taken up for admission. 32 Leco reflects that the petitioner have not taken steps for service of notice upon the respondent number 4 despite be repeated here. Who is appearing for 32? Anybody appearing for 32? List the matter again on 13th of February 2026. 32, huh? 33 contempt, again 16th.
13th, my lord, order has been complied with, my lord.
Huh?
Order has been complied with.
32.
33, my lord.
33. Mr. Esbora appearing on behalf of the petitioner, respondent GMC,
GMC, lord.
submits that the order so dated so and so, passed in WPC number so and so, have been duly complied with. In that regard, he has placed an instruction dated so and so,
4/2/26.
dated
4/2/26.
4/2/2026, which is kept on record and marked with the letter X. Taking into account the above, nothing further remains in the instant contempt proceedings for which the same stands dropped. 33. And 34, service not completed. Who appears for 32? Anybody? No. 34, service is not complete.
I am for respondent 1, Lordship.
Who appears for 2?
2, perhaps my friend.
You are appearing. Okay, Mr. Seaboru appears on behalf of the respondent number 2 and submits that he would like to file an affidavit in opposition.
Yes.
So in fact, Lordship, what happened, Lordship, we have submitted the pencil proposal before the AG, Lordship. They have returned with certain queries. That queries you have written to the APRT and PG department, Lordship, for clarification.
And we do one thing.
Lordship,
Service upon the respondent number 2 is complete.
Lordship.
Was taking into account the above, list the matter again on 18th of February 2026. The councils who represents the respondents shall also apprise as to what is the present status of the pension proposal of the petitioner on the next. Yes, what is there? Matters are finished. Huh?
Item 28.
Ah,
Okay. The address of the respondent number 6 initially was in Silpuguri, Guwahati. I took step again get changed their office to Hathigaon. So ADS not again take steps. Hathigaon now presently November it is in now. I have filed an additional affidavit. It is now at wireless party. So I may be allowed to take steps. Here.
Mr. So-and-so appearing on behalf of the petitioner submits respondent number
6.
6. The respondent number 6 present address
House number 18.
is house number 18,
Island number 1.
byline number 1,
Wireless.
wireless
Guwahati 78100.
781006. Pusto. Taking into account the above, the petitioner is directed to file a fresh memo of parties by incorporating the correct address of the respondent number 6. Pusto, the petitioner further shall, on the basis of the said address, take fresh steps upon the respondent number 6 by way of speed post within 2 days. Within 1 month? Please take on.
31, my lord, item number 31 orders, not called.
What is there? No rejoinder filed.
Is it already settled by this court?
There's also one set the order lodge. In the situated persons are filed different petition, which was allowed on set aside the same in order. They again find the we can report the dividend bench also upheld the order of the president. So this is the
So at 20 also you won't leave me.
Actually, in compliance of sixth pay commission recommendation, the petitioners along with others, pay was revised, but wrongly revised to high and pay the excess amount. Very fast. Similar,
Comments of the order, Lordship.
You want the disposal as per this?
yes,
Shall, we'll dispose it.
similarly situated person.
Okay, we'll dispose it of. The dictation did not. Anything more?
Item 29 has been complied with, Lordship. Lordship as a rejoinder has not filed. Lordship may just fix any date. I'll place my compliance order on the next date.
You have it?
Yes, it's a speaking order, Lordship, that was required. Yes. I have the, but I don't know if the 29, yes, 20, huh? Item 29.
Mr. A. Solia, who appears on behalf of the respondent number,
One, Lordship.
submitted that the order dated
2012-21, Lordship.
2012-2021 passed in WPC number 2307/2019 have already been complied with by the speaking order dated 12/12/2025.
That is a speaking order, Lordship.
Taking into account the above, the instant contempt proceedings stands dropped. Full stop. It is however observed that dropping of the instant contempt proceedings shall not prejudice the petitioner to assail the speaking order dated 12/12/2025. If so advised,
Sir, I'm giving a
the
copy of
instruction so the speaking order so produced is kept on record and marked with the letter X.
Supplied a copy to the petitioner also, Lordship.
You got a copy? Your name, give it your name. Okay.